And boom.
Boom. Do you want an F-bomb? I can do an F-bomb.
I need to get an F-bomb.
Do you want an F-bomb? I'll toss an F-bomb. We'll do that. Toss
There
me
we
an F-bomb.
go.
There we go. Toss me F-bomb. Boom.
All right. So welcome back to the new and improved Trials of the Century, episode 2, which is a long time delayed from episode 1, but that's mostly on me.
And me. This is a two-party gig here,
It's
buddy.
like 75-25 on that one.
I don't know about that, but sure, I'll let you stand in front of the railroad tracks for that one.
There we go. Today we're covering a case that is not big in the US because the US followed a different path to get to the same principles. But if you are outside the US in sort of the Commonwealth, which is lots of the world, this is a case you almost certainly study in law school. And that is still relevant because basically it says that this case is the reason why I can enjoy a nice, drink without needing to worry that it's going to kill me. Much.
Well, I was going to say, really? Well, and you know what, Ian? You know what we always do every time? Why are people listening to us talk about a case in history? Why is it relevant that we're talking about it? Because they don't know us from Adam.
Well, that's a good point. I will introduce myself. My name is Ian Runkle. I'm a criminal defense lawyer and firearms lawyer in Canada. And over to you.
Okay, my name's Rob. I'm a channel's Law and Lumber, not Runkle of the Bailey, although we are often on each other's streams. And I'm a domestic relations litigation attorney, basically divorce, family law, etc., and bankruptcy litigator in Virginia in the U.S. So we cover these historic trials, going back over these trials that we've kind of labeled trials of the century. So.
Yeah, although some of them I think are technically more than a century old.
Yeah, that's fair. Trials of their century?
I think just trials of the century works. But these are sort of the trials that change things, the trials that end up being really significant in terms of how the law works or how people think about the law. Because some of the cases, like the McDonald's, hot coffee case, that didn't really change how the law works. But it changed how people think about the law.
Yeah, exactly. So we try to break down these cases. We had a goal of doing one per month. We're going to get back to that goal. I promise we will. And we switch off on picking these particular trials. I pick one, Ian picks one, I pick one, Ian picks one. And this week, Ian picked one that has me questioning my drink of choice.
I was planning to have a dark and stormy here, but I did not manage to make that work. Maybe I should get on like Skip the Dishes or DoorDash or something and have them see if I can get them to deliver me, something along those lines. Because if you've got a ginger beer, you may want to switch to, Coke or something for this one. Maybe not wine and Coke.
Well, you've been an advocate for that for a while, so I'm surprised to hear you say that.
Well, I'm just saying that because you're here, and I know it offends your sensibilities.
Very much so.
So, this is the case of Donahue and Stevenson, and that's so. This one is a bit of a weird case, and it's got a bit of a storied history. So let's pull this up here. And this is a beginning. This is a quote from the decision at the House of Lords, which is like the Supreme Court equivalent of the day. So it says, "I do not think a more important problem has occupied your lordships in your judicial capacity, important both because of its bearing on public health and because of the practical test which it applies to the system under which it arises." So basically he's saying this is the most important case of our time, which already sounds like he's saying this one here is a trial of the century. Even back then, that's what he was saying. So let's go to our next page here. So we got our cast of characters, and this is who all is involved in this case. And so we start off with May McAllister / Donahue. Now, this one has caused people all sorts of consternation, because apparently in Scotland, with married names, they would list the maiden name and the married name. And also because of other reasons, they spelled McAllister in different ways in different places. But Donahue is just who we're going to call her. She was poor, and by poor, she actually filed to be recognized as a pauper, which actually gives her special privileges in court. If you're poor enough, the court may cut you some slack. So that freed her up from having to pay filing fees, was one critical thing. And the other critical thing is that it freed her up from having to pay what's called security for costs. And security for costs is basically, if you lose the case, then you're expected to pay money. So security for costs comes up in situations where they're worried that you might not pay. And
an
so
appeal
they'll ask
bond.
you.
It's like an appeal bond.
Yeah, basically, it's you pony up money so that it's there for the other side if you lose. But she filed an affidavit that said that she was not worth more than £5 to her name, exempting the clothing on her back and the subject matter of the appeal. So basically, the only asset she's really got is, I've got this court case.
It's a pretty solid affidavit. Like, literally, I have the clothes on my back in my case.
She also had letters attached to it from her priest, who described her as very poor, and other community members who all backed up that she was poor.
Okay.
She worked as a shop assistant, and she was separated from her husband, from whom she would later get a divorce. And of course, this is back in the era where being separated from your husband typically went right with poverty. There's not a lot of pictures of her, but here's one.
Well, and I think that bears mention here, because a lot of the terms that we're going to use in these cases, they're going to be terms that you're not used to hearing in regular everyday parlance, because these cases are old. And when we use a term like, for example, filing for pauper status, these are legal terms. It's not us labeling it. This is what the law labels the individuals that are filing. And
in fact, we still use that term.
Do you?
Well, there's a Latin term. What is it?
In pauperis.
Yeah, which is basically, I am a pauper.
Yep, it's the same thing. Yep, we still use it.
So, and that's because the law loves its old-timey language and so forth. So, yeah. But, yeah, she was quite poor, which also makes this a bit of an unusual case, because who takes a case up to the highest court in the land? Typically people with money.
Mm-hmm. I have to say it now, right?
What's that?
I have to say it now, right?
Absolutely. Go for it.
Comes now May Donahue, plaintiff in the underlying litigation.
And it would have actually been appropriate to say that in her era.
Yep. And in Virginia now.
Yeah, well, it's just Virginia hasn't updated the language since since then. But so that's Ms. Donahue. Mrs. Donahue, technically, at the time. And now we've got Francis Minghella, who's actually, they spell his name different places. They put Minchella in some of the things, and I don't know why, but apparently this is the correct spelling. Now, he owns a place called the Well Meadow Cafe, and his occupation is listed as confectioner. So what does that tell us? This guy is basically running an ice cream shop.
Okay.
So that's sort of what he does for a living, is he sells sweets. Later, after this kerfuffle starts, he gives up his business and decides he wants to be a road worker instead. So
That's
he
a bit of a
sells the
change.
business. It really is. He's like, I'm done with this. I'm gonna go. And I
On
mean,
roads?
yeah, he becomes a laborer that works on roads.
Okay.
So I mean, that is impressive. We've also got as a cast or in our cast of characters, David Stevenson, who is our main defendant here. He is listed as an aerated water manufacturer. So what is aerated water?
Sparkling. It's spicy. It's spicy water. It's spicy water.
Yeah, it's sparkling anything. So root beer is aerated water. Coca-Cola would have been aerated water I don't know if it existed at the time. And ginger beer is aerated water. Anything that was carbonated was aerated water. So you see these aerated water manufacturers listed by that title in a bunch of places.
Yep. If you own a soda stream, you're an aerated water manufacturer.
I mean, now it's cheap to get into being an aerated water manufacturer. You can just do that at your local grocery store. You can pick one of those up. So he dies in 1932 of a bowel obstruction at age 69.
Oh God.
Yeah.
Okay.
So
Stevenson dies in 32, and we didn't mention this. When was this case? When are the incidents taking place? Like, when are we talking about?
The allegations
here we go.
1928. So plaintiff and her friend. Nobody in this entire process thinks to write down the friend's name. So her friend's name is lost to time and space. Like, that is just, we don't know who this is. Now, some commentators have speculated that this was a romantic relationship. That's unlikely because, first of all, the friend was female. They did specify that. But also, there's just no indication of it whatsoever. And if the friend was female or was in a romantic partnership, they probably wouldn't have brought the suit because of the time frame, and you wouldn't want the attention on something like that in that era. Now the friend is paying. She's paying for everything here because we already have established that Ms. Donahue is dirt poor. She's got no money. But her friend is paying a bit of money out, for them to have an outing. And the friend orders a ginger beer and ice cream for Ms. Donahue, which is apparently called like a Scottish float. And this happens in, I think, Edinburgh. So I actually,
case.
It's Scottish. Yep. Now I got to actually look up where Donahue and Stevenson, which town it is. But it is Scotland is the fundamental thing here. So it's not the US. It is not Canada. It's way off. So the town is Paisley in Renfrewshire. So, yeah. If you know where that is, great. I don't. But the friend orders for herself a pear and ice. And I don't know what that is.
I guess like frozen pear or like pear concentrate and sure.
Or maybe like it's a pear with ice cream, possibly.
Or it's a confection involving pear and ice. You guys can do the math.
Now, the reason why it's important, why I mentioned that it's important that the friend is the one paying for the ginger beer, is that this is a case that is not a contract law case. And that is a thorny issue legally here. So the friend buys the beer, and then the plaintiff drinks the ginger beer float. And after she's drank a bunch of this ginger beer float, her friend apparently refills refills her bottle and out floats a rotting snail.
I was waiting for this part. Yeah.
And after this, she becomes ill, partially because of the shock of going, "Oh, I just consumed that," but also, possibly because of disease. So she suffers a bunch of consequences, which we can go over here, because yeah. So the allegations in terms of injury, severe shock, prolonged illness, sickness, and nausea. She gets diagnosed with gastroenteritis. She needs to get emergency treatment at some point. And she says she has no stomach troubles prior to the incident. So, but she says she's unable to work. She's lost wages. She's just out of it. So she wants 500 pounds plus 50 pounds for costs.
See, and I appreciate that you did the adjustment for inflation.
Yes.
Because that was where my head went. Like 500 pounds, that seems like, why is that just not being paid out immediately? And then when you adjust it, it starts to make more sense. It's 45,000 US dollars adjusted with inflation. So
yeah.
Not
If
inconsequential, but
I mean, it's still the kind of money where if you sue your local McDonald's for $45,000, they're going to hire a lawyer and they're not going to settle. They're not going to pay you the 45,000 right off. Whereas if you've got a decent claim and your claim is for like $200, they're probably like, here's $200, go away.
yeah.
Not legal advice, but just, practically speaking. And I mean, she wants her, like she says, she's out this money. She wants the money. The defense from Mr. Stevenson is a few things. Now, have you ever had the reason to write a statement of defense?
All the time. Yeah.
All the time.
Admit or deny, and then you basically say what you have as far as affirmative defenses. But yeah.
Yeah, and statements of defenses are, they're often, they kind of piss people off to read them. Because they basically say, like, first of all, we deny plaintiff exists.
Yep.
If plaintiff exists, then we deny that they ever got hurt or that they ever actually attended our business. If they attended our business, we deny that they got hurt.
Yep.
If they did get hurt, then it wasn't our fault. If it was our fault, then it was also the plaintiff's fault. And in the alternative, a wizard did it.
Or a random flying monkey.
Yeah, it's like, if you've seen the Narcissist Prayer, that's basically how you write a statement of defense. You haven't seen the Narcissist Prayer?
No. While you're pulling it up, because I know that's exactly what you're doing right now, because that's how your brain works. The way that these phrases are written in an answer is, defendant lacks sufficient information to form an answer in the affirmative or negative, and therefore denies the same and demands strict proof thereof. It basically says, this is an allegation you made. I don't know if it's true or not. You got to prove it. I'm going to deny it until you prove it.
So the Narcissist Prayer is, that didn't happen. And if it did, it wasn't that bad. And if it was, that's not a big deal. And if it is, that's not my fault. And if it was, I didn't mean it. And if I did, you deserved it.
Oh my God.
That's basically a statement of defense.
Kind of. It's upsetting, but it is true.
So his defense is, if she got sick, it wasn't because of our ginger beer. Our factory is the best known in the trade. Her alleged injuries are grossly exaggerated, and any illnesses suffered were due to the bad condition of her own health at the time. And they go on to say, we have never actually issued bottles that match the description that she has given. And
this is interesting.
This is interesting. I got to go back a few slides because I forgot to put that here. This is the bottle. And so the bottle is a brown glass bottle. marked Stevenson, Glen Lane, Paisley. So, yeah, it's kind of the question of if nobody is issuing bottles like that, how does this bottle come to exist? Is somebody framing you with a weird bottle? Yeah. Now, did we talk at all about why the bottles would be like this? I don't know if Rob's around at the moment or if he's in the washroom, but
Yes, we did. We did. So that was the question I was going to ask about the bottles, because the bottles are important, because from my understanding, at that point in time, bottles were reused, and they didn't necessarily relabel the bottles. They just washed them and reused them. So you would return the bottle and they would reuse them. And it didn't really limit itself to, you would return the bottle to Stevenson. You could return the Stevenson bottle to anywhere, and that place might use the bottle, wash it, and serve it with their own drink, right?
They actually had a system of private bottle deposits. So when you got a beverage, part of that money would be a bottle deposit. Essentially, there'd be a reward for it, and so you'd take it back to a person whose job it was to collect bottles, and that person would wash those or would sort those bottles out and return them to the store or to the place that they came from, and he'd get paid, for those the return of those bottles. And the bottles are dark glass for two reasons. One, it was cheaper, but the other thing is it keeps light out, and so it makes the product stay good longer.
Yep, because light invites bacteria growth, etc.
But the problem that you have with a dark bottle like this is you can't see the contents. Same thing with a can, right? There could be anything in this can, and I can't see it because it's opaque. So but they later dropped this claim of the defender has never issued bottles answering the description given by the pursuer. Because I think the court was going to call bullshit on that.
Properly so.
Who else is issuing these bottles? Come on.
Yeah.
So, now here's our legal problem. And that is that this is before we have the law of negligence, which means that you would have to sue for this under contract. And contract's a big problem here. This is a thorny contracts problem.
And you used a word in this slide that I got when I looked at your slide deck.
Yeah.
This is one word I was like, we need to pause here. Because you use this magical word, privity.
Yeah.
And it's a magic word because it's a law word. And it means a lot with just that one word. But privity of contract. Privity of contract basically is the only individuals bound by the contract are the contracting parties. You have to be in privity. So that is, if you imagine, so extend that word to be private, right? So there's a private relationship, a private agreement between two parties. The public at large doesn't know the arrangement. They don't have the right to sue under the arrangement. The only people that can sue under the arrangement are the private parties to that private arrangement, right? So contract. So I buy something from Ian. We are in privity. Ian knows what I am paying. He has agreed to that amount. I know what I am receiving. I have agreed to receive that. Ian knows what he's selling. So that privity of contract extends to agents. So if I hire someone to buy the thing, it extends to very limited third parties, where if someone knows that I bought the thing and they have a benefit from the purchase, right? I buy it as a third party, and I buy it to benefit this third party, and everyone knows I'm buying it to benefit the third party. When I buy a toy for a child, everyone knows.
I mean, let's say Rob ends up, he breaks his hip and can't walk around his house. And so I hire somebody to clean his house and fetch things and so forth. I'm looking out for Rob. I hire that person, and that person knows that they're being hired by me to take care of another person.
Yep.
If they don't show up for work, Rob is in the, like, my damages for that are not really anything because it wasn't going to matter. Like, it's not helping me specifically, but Rob would be then in a position of privity because he's the third party recipient.
And
But
you knew.
and but you can't, like, you don't have privity with the universe. And so there's all sorts of places where I might want to sue somebody for them breaching some other contract, but I can't.
Can I make? I'm gonna risk saying something that might be. It's a today issue that might help put this into context. If I am a standard taxpayer, I cannot sue. The student loan forgiveness stuff. I can't sue an administration because someone else is receiving a benefit that I feel is unfair. I am not anywhere in that contractual relationship. I don't exist in that capacity. I can't sue to stop that or to enforce it or to do anything with it. I have no relation to it.
Or another example is, let's say I live in a town on a river and the bridge collapses. The city hires some contractors to rebuild the bridge. And that bridge, they say it's going to be up and running in 3 months.
Yep.
And then the contractors, 6 months rolls around, they come back to the contractors and the contractors goes, I'm not going to do anything about that. Like, screw it. I'm taking the money and I'm running. I'm not the city, but I am a person who wants to drive across this bridge. I would really be benefited if this bridge existed. I cannot sue the contractor for the bridge, for them failing to do their job on the bridge. If the neighbor starts building a house on their property and their contractors stop doing anything and it becomes, and it's ugly because it's a half-finished house, I can't sue those contractors. There's just, and that's really because otherwise a contract, you don't really know how much liability you're buying into. Contracts are supposed to be deals between, like, the people involved, not something that creates liability to the universe. And, if we didn't have this rule of privity of contract, then theoretically a contract you agree to, you could get sued by anybody who was upset by it.
That's why I went off screen for a minute.
Oh, you had to move put the flag tie back?
All this discussion of privity and exchanging of goods and all these things, and there's a tie on Ian's doorknob, but not the tie behind me, so I had to fix that.
Fair. So I did a little diagram here of contract issues. And so, this is basically a charting out of our contracts and non-contractual arrangements. So Stevenson, our manufacturer, he makes the ginger beer. He's got a contract with Well Meadow Cafe. He sells them directly the ginger beer.
Mm-hmm.
Well Meadow Cafe then sells it to our mystery friend.
Yep.
They have a contract, but you'll note no arrow between mystery friend and Stevenson. They never met. They don't have any agreement. They have no deal. And then the mystery friend gives it to Mrs. Donahue. And a gift is not a contract.
Mm-hmm.
So, and this can be a really subtle distinction. Like, let's say I sneak a tie into Rob's luggage. That's a gift, right?
Mm-hmm.
And if Rob doesn't like that tie, if he thinks it's a crappy tie, he cannot sue over that. But if I sell Rob a tie, even for like $1, if that tie doesn't do important tie things, then you could sue, right? So, yeah. So Mrs. Donahue can't sue her friend for this gift of this mystery of this thing under contract. So yeah, that's sort of our problem here. And she's got privity of contract with nobody. So
Yeah. She's a third party beneficiary by gift to a relationship that existed between the friend and Well Meadow Cafe. Well, the friend sent the money, gave the money to Well Meadow Cafe for a ginger beer. They expected a ginger beer. They paid money for the ginger beer. They got a ginger beer. The ginger beer had something else in it that was put in by the manufacturer. So arguably you could connect those dots, but this one is one connection further than contract would allow.
Well, even the mystery friend can't sue the manufacturer because she doesn't have any connection to him. And she could sue the retailer, but the problem is that the retailer is also innocent. You're never going to make out a claim against the retailer because the retailer had no way to check for snails either.
Well, that's arguable. And I think that there's a debatable thing here. Here's the thing. The legal problem would have been a lot easier for the court to reach if the mystery friend was suing the manufacturer, because the manufacturer, arguably, when they entered the contractual relationship with Well Meadow, would know that Well Meadow was distributing that to third parties.
The thing is at the time, there was no negligence suit available. It was just a contract suit.
Just contract.
And so she can't actually get to the manufacturer through that. And this is becoming a big problem in this era because this is a time of change. They were stuck with legal rules that actually predated what they were up to in ways that caused them some big problems. And I think we'll... we've got, why does privity matter? Contracts are binding agreements between the parties, not the universe. Rights under a contract come with obligations, because a contract is two ways. And so if you can have privity of contract with a random person, then theoretically you could also stick them with obligations too. And that's no good. Like if my neighbor's building a house, I don't want any obligations relating to that. Screw that. Leave me out of it. You build your house.
Yeah.
And the last thing is that we have this doctrine of efficient breach.
Yep.
And efficient breach isn't recognized everywhere. Some places still punish it.
I mean, you chose a case that went like deep into the law. This is okay. We need to explain efficient breach. Like in a very... What's the best hypothetical you can think of for an efficient breach?
So let's say I'm selling Rob pig iron, and I'm selling it to him at a particular amount per ingot.
Oh, yeah.
And
good one.
Rob wants to buy my iron because he's making widgets. And right now, widgets sell for $30, and he can make 3 of them with $30 worth of pig iron. So he's making money on this. But Rob's factory is only set up to build widgets. That's it. Like, that's all he can do with the pig iron. The price of widgets crashes, but the price of pig iron skyrockets. So I have a deal to sell Rob pig iron at $30 an ingot, but I could sell it to anyone else at $90 an ingot.
An important thing, you cannot increase the price on me. You cannot. We are locked in at that price.
We're locked in.
Yeah.
But Rob doesn't want a minimal amount of pig iron because he's going to have a lot harder time reselling it if he's trying to do that to make a profit. He's like, I don't want to get stuck with a bunch of pig iron I can't use because the price of widgets has crashed.
Yeah.
And it'll actually cost me more to make the widgets than I'll make out of them.
I want to retrofit my factory to make something new and not have to deal with the widgets that I was previously making.
So at this point, it's far more efficient if I say, you know what, Rob, I'm not selling you the pig iron. I'm selling it to someone else at $90. And, and that's actually true even if Rob is actually keen to make widgets. If Rob is keen to make widgets and he's willing to pay up to $30, an ingot for pig iron to make his widgets. But let's say there's a disaster somewhere else and they need a ton of pig iron. and they come to me and they say, we need pig iron right now. We're going to pay $90. It's actually more efficient for me to tell Rob, hey, listen, sucks to be you. I'm paying out your value of what you would have earned, but I'm selling the iron to the people who need it more and are willing to pay more.
Yep. And that is more efficient because you're still making money on the deal. And this is a good question.
Yeah.
Why are attorneys obsessed with widgets? Should I make widgets? The attorneys are obsessed with widgets because that's what we learn in law school. You need to be able to describe something, a hypothetical thing that's being created. So you describe widgets, just like every piece of property
is black acre, white
is
acre,
black acre,
green acre,
white acre,
yeah.
yellow acre. Yeah.
So all of this is, efficient breach. Rob, I still have to make good on, things. If Rob was going to make $45 from each, ingot, I still have to pay Rob $45 for every ingot I was agreed to sell him.
Yep.
But if I'm now making $90 from those, in theory, everyone's happy. Rob gets paid off from me. I get to sell my stuff at $90 an ingot, and I get more money. And the people who are buying it at $90 an ingot theoretically are happy because they're getting to buy their iron. So that's the idea behind efficient breach, is that in theory, sometimes it makes sense for a deal to be broken.
Yep. And this is a good point. Wouldn't I be mad? Even if I was mad, the most that I would stand to earn is what I would have sold the widgets for. So as long as Ian pays me that, I can't be mad. My damages have been fully remedied. I can't get more out of it.
And contract law very rarely deals with feelings.
Nope.
Contract law is all about money, and the one exception to that is when we get into specific performance. And specific performance can be so normally contract law, you can't get the thing you were contracting for.
Nope, Ian, this is a sidetrack. I'm not allowing you to go down.
Okay, sidetrack. I'll just say it's the only time we really deal with feelings, and other than that, we'll just move on.
Yep, different case, entirely different concept. Our brains are going to be scattered.
So the legal action here is that she brings a writ against Stevenson, the ginger beer maker, and says, I want 500 pounds. And he says, I want this case thrown out. And the basis for it being thrown out is he says, listen, you don't have a claim the law recognizes. You don't have a contract with me. You can only sue under the contract, and there's no contract. Because at this point, the law did not recognize the concept of negligence for products. So if I'm a baker of bread, and it turns out that this bread is contaminated with cyanide, which is literally an example that gets used in these cases. And you buy the cyanide-laden bread, you can sue me for breach of the contract to sell you bread, but if you then give it to somebody else, that person can't sue. No matter who that person is.
Doesn't seem right. So this is where the law starts to step in. Yeah,
and we can look at some of the previous case law, because the previous case law is messy and also kind of illustrates why this rule ends up being so important.
Well, and before you do that, catch up on Super Chats, because I want to make sure that we're staying on topic.
Oh, yes. David Chatton, thank you for the new membership. Much appreciated. Patricia Delbay, thank you for the new membership. Much appreciated. Lindsay says, alas, no ginger beer for me tonight, as I'm sitting on my BFF's cat for the week. Hopefully not on, but coffee martini instead. That's a good instead. Debbie W., thank you for the YouTube membership. Much appreciated. Paige, thank you for the membership as well. Much appreciated. Andre Vander Els, thank you for the membership. And that looks like a badass guitar. Grant Horn says, landmark trials in legal history. That's a good... Might be a little
It's
too
good.
many syllables.
That's good for this one, but for the trials as a whole, I think we need to remain trials of the century.
And if Rob lost even more money due to not meeting other contractual obligations due to lacking widgets, could Ian be responsible for even more money? I think potentially I'd have to cover whatever your costs are.
Potentially, however,
It gets complicated.
under this old law, Ian would have to know that. Ian would have to know in providing me those widgets that I was using them for something else.
Yeah. Contract law doesn't typically have you owing for things that you are not aware of.
Correct.
We've also got some gifted memberships to cover there. And Joshua Ten Hag, thank you very much for the super sticker. Rhineman YYC, thank you for 10 gifted memberships. Joshua Ten Hag, thank you for 10 gifted memberships. Sandy, thank you for 10 gifted memberships. Pants, thank you for 5 gifted memberships. Pants, I got to get in touch with you about some metal products. Lady Draconis, thank you for 5 gifted memberships. Joshua Ten Hag, thank you for 5 gifted memberships. Baby Gator, thank you for 10 memberships. Angie Torres, thank you for 10 memberships. And Brentwood Chic, thank you for 20 memberships. Much appreciated. Whoops. And somebody is saying, what do gifted memberships do? They give you a membership for a month. And when we do the behind the scenes of the Trials of the Century, it's good to have a membership because those are members only. I'm going to start doing some more members only, like Leatherwork streams and stuff. I just need to actually do those. So
for example, Ian introduced this case to me in a behind the scenes members only, and the trauma that I experienced on my face in learning about this trial, that's the benefit of the members only, because I hope to bestow that upon Ian with the next choice of trial.
Oh God. So the previous case, and this one's actually kind of important to talk about in context. Mullen and Barr and Company from 1929. That's real close in time. We're going to get to the connections here because it's all connected.
Mm-hmm.
So the plaintiff bought and consumed ginger beer. Ginger beer at the time seems like it's incredibly dangerous.
Yeah.
The plaintiff discovers a dead mouse in the ginger beer.
Why?
So, all sorts of animals ending up in these things. Now, some people have speculated that Mullen was, they said, like, how does a mouse end up in a bottle?
He planted it.
I mean,
that's the speculation.
That's the speculation. That said, I've seen mice climb through very small openings. So, I don't know. But the plaintiff sues and loses. And the reason why they lose is the contract issue. The court says the general principle established by the authorities would seem to be that a man who puts his product manufactured by him on the market has no duty to anyone regarding it except to the person with whom he contracts, unless A, he knows that the article which he sells is dangerous and conceals that knowledge from the buyer, in which case he is guilty of a fraud, i.e. if you knew there were mice in there, then you're committing fraud. Or B, he is a dealer in articles which are per se dangerous, for example, explosives, and gives no warning to the buyer of that fact. Now, did you have a look at Mullen? Did you catch who the victims in Mullen were?
I only looked at the snippets that you captured. I didn't pull the whole case. I trust my Canadian lawyer to fill me in on that.
So Mullen's, the injured party in Mullen was the kids of the person who bought the beer, the ginger beer.
Oh.
And so when you think of like who might be a third party recipient,
that's pretty close.
Children are a really common one.
Pretty close.
There's another case where somebody bought a product, like a hair product, for their wife, and it was dangerous. So, yeah, this beverage may contain peanut oil or mice. Yeah. Mullen has some other, I'd say, great quotes, but not so much. Says the theory is ingenious and at first sight plausible, but I cannot regard it as convincing or sound. This is the theory of the manufacturer being liable. Let me examine for a moment the proposition on which the argument is based and see exactly what it connotes. It connotes that the duty of the defender's servants was to ensure that all sediment was cleaned out of every bottle in their factory before it was refilled and sent out by them. The bottles being dark in color, it is manifest that the defender's servants concerned could not have detected a mouse in the bottle. At best, it would have represented to them a certain foreign matter.
What the fuck?
So basically, the court is like,
Like,
do you
no.
really expect them to send out
Yeah.
0 dead mice?
Do we expect the workers, and in this case, the language part, the servants to inspect the bottles before they Yes.
yes.
When you're refilling them with something that I am drinking, I expect you to look inside the bottle.
I mean, nowadays we look at that and we go like, yes, of course we expect that.
Yes.
Like the number of mice I expect to find when I buy like a 12-pack of Coke.
0
mice.
Yes.
In fact, I've been drinking Coca-Cola my entire life. I have found 0 mice in cans of Coca-Cola.
You need to find a piece of wood and knock on it immediately, because if you find a mouse in Coca-Cola next week, we're all going to be really traumatized.
And I'm going to sue.
I feel like this is begging for the old Virginia, because the language is crazy.
Well, and then the pursuer's contention under this head really involves that it was the duty of the defender's servants to ensure the complete purity of the contents of their bottles, failing which the liability in law would attach to them. But that contention is just another way, it seems to me, of stating the warranty argument, which the pursuer expressly gave up. They're like, listen, you didn't have a warranty that these were mouse-free.
So now you are seeing the beginning of disclosures on bottles and on packaging, where people are saying, warning, might be hot. Warning, might contain a mouse. Warning, could have snail contents. Like, oh.
What I suspect it probably said is, we specifically disclaim all warranties with respect to this product.
Probably.
And but nowadays we really do expect that there will be complete purity of contents.
Mm-hmm.
So, yeah. And it continues because, of course, it does. This case is horrific.
You want me to read this one?
Oh, go ahead. Yeah.
Shall we do the old Virginia to match the? Well, it's Canadian, but
Scottish.
It would be Scottish. I can't do Scottish.
I can't either.
We'll just do it now. If that be the law, it leaves the defenders unscathed. They were admittedly unaware that the article sold by them, which is normally safe, was dangerous. And they certainly were not dealers in an article which, per se, is dangerous. It's impossible to assimilate the position of a dealer in, what the heck is that word?
Gelignite.
Gelignite?
Gelignite.
Oh, fiery gel. Got it.
Yeah. That is nitroglycerin, gun cotton, wood pulp, and potassium nitrate. Also known as blasting gelatin.
Yep.
So if you've seen Fight Club, when he's got the truck full of tanks of blasting gelatin, that's what they're talking about. Like, hey, this could destroy a building kind of thing.
Yep. So it's impossible to assimilate the position of a dealer in explosive paste with the position of a dealer in ginger beer. That's okay. As Mr. Watson, for the pursuer, invited us to do. The pursuer has bought from a retail dealer a bottle of brewed ginger manufactured by the defenders and had given part of the contents to his children to drink. Seems reasonable. He alleges that the brewed ginger contained deleterious material, which injuriously affected the health of his children. He further alleges that the injurious matter arose from the decomposed body of a mouse, which had been allowed to remain in the bottle through the negligence of the defenders or their employees. The sheriff of Lanarkshire dismissed the action as irrelevant, holding that the defenders owed no duty to the pursuer with whom they had no contract. Well, that's okay. That's one way
Yeah.
of reading it.
Your kids can't sue because the kids were supposed to buy the ginger beer themselves. Is basically what this comes down to. Direct for the the manufacturer.
What a crappy reading of the law.
Well, and this actually was the law at the time, and it made more sense at the time because of context. And that context is this: the Industrial Revolution. And let's just talk a little bit about how the Industrial Revolution changes things. Prior to the Industrial Revolution, if I needed, I don't know, a horseshoe, I would have to go to the blacksmith and buy the horseshoe from the blacksmith. And, if I needed food, I was probably buying it from either a farmer or a guy like a retailer who would have like buckets of apples and buckets of grain and whatever else. Now the Industrial Revolution changes that, because now it becomes possible to have manufacturers who you never meet and who turn out thousands of things.
But can I push back on that with the Mullen case? You made the point of the children. So you're saying I could walk into an establishment that serves food with my family.
Yeah.
Hypothetically, and my family is there, and when I walk in, the owner sees that I am there with my family. My entire family sits down, and I pay the bill. And among the food that is consumed at that table, there is a mouse.
Yeah, or
under something.
Yeah,
there's a widget.
Your wife orders the fish, and as it turns out, the fish was fresh last week.
Or it comes out with brick in the fish.
There's literal brick in the fish.
Brick in the fish. How? Well, and I think that's the concept that I kind of have difficulty with, this being the first instance where this has occurred.
Yeah, it's it becomes a much bigger problem is the thing. A much bigger issue. Because now most of the products you're buying might be made in this process, as opposed to, some of the products or whatever else. So it does become a much bigger issue.
Mm-hmm.
Like before the Industrial Revolution, you wouldn't have an aerated water manufacturer. You'd have the cafe owner who also has vats in the back that he, makes. Like if you wanted to drink beer, you went to the brewer. And your bartender, your bar would also probably have, have brewing stuff in the back. In Texas, Kurt and I went to a whiskey shop, like a whiskey establishment, where they had the stills in the back.
The stills are in the back.
Yep. And, we went on a tour of the stills, and it was pretty cool. But not a lot of businesses where you deal with that. Food safety worker here. I mean, food safety workers are largely employed because of decisions like this.
Kind of.
And regulations.
And that's the thing. The government steps in and starts saying, we need to fix this.
Now, this is the really fun thing, because there's a lot of connections to the Mullen case.
Jeez.
Mrs. Donahue hires Walter Leachman. Leachman was also counsel on Mullen. He was representing, it was like Mullen and somebody, I forget who that was. He and Mullen and he was representing one of the co-plaintiffs. He loses Mullen 3 weeks before this.
Wow.
And then he files this case. Now, doesn't that seem weird? Because if you lose a case 3 weeks prior and the court says, listen, the law does not allow you to bring this kind of application, do you immediately turn around and file another application?
I think you do. I think you do because it's based on the facts that he had in Mullen. And this is a different set of facts. And
is it though?
You
because the only difference is really the mouse versus the snail. Because you still have that same shape of, the contract problem.
Yeah.
Now,
I don't know.
This is a fun question on judge shopping.
Are you saying, and that's a good question. Are you saying that this, because the thing is, in Virginia or in a lot of the states in the US, if you file a case where you know, based on existing law, that case is bunk, it shouldn't be filed, you can get sanctioned for that. However, you can still have a good faith exception where you believe that an extension of law or that the law was wrongly decided, you can still file the case. This is judge shopping.
A little bit. Now, the fun thing about Mullen is that Mullen, they won at the lowest court level where they filed it. And then they lost on appeal.
So he knew there was, so the thing is, the attorney knows that there's this conflict in the law, that judges want to make the right call because it goes on the gut to make the right call. And they're trying to force the appellate court to see the logic.
And now we introduce another character in this whole fun story. That's Lord Moncrief. This is the guy who hears Donahue and Stevens at the local court level, who is the same person who heard Mullen at the local court level and who had refused to dismiss Mullen.
Oh, so Moncrief's pissed at the appellate court. Moncrief thinks the appellate court got it wrong, and Moncrief's like, I'm going to write my opinion in a way that now I'm going to kick it upstairs because I know it's going to get appealed. I'm going to kick it upstairs, but I'm going to write it so you guys take a different look at it. So this is Moncrief's second bite at the apple.
It's the lawyer's second bite at the apple. It's Moncrief's second bite at the apple.
Wow.
It's everybody relitigating this case. And he basically says, I am not dismissing this case. Now, I mentioned that Mr. Minchella or however it's pronounced is in the case. He is in the case for all of a few months.
Now, he's the confectioner.
He's the confectioner. They add him to the case, and then they drop him from the case. And the reason why they probably drop him from the case is that, first of all, there's still no contract. Donahue and never bought anything from him. And second, he's got no way to know about the snail either.
So from a legal standpoint, this is like the riskiest strategy you could take. Literally the riskiest strategy. You are shucking every principle of law that exists that could get you to liability. You're saying, nah, I'm going to go on this new theory that has never been argued, and I now want manufacturer direct liability.
Yeah.
This attorney,
which has never existed before.
Wow.
Except for things like explosives.
Yeah. So, okay. Wow. So the attorney basically says the only avenue that I have contractually is through Minghella.
Yeah.
I'm going to
blowing that up.
We're believe so much. I'm going to believe so much in my case.
Yeah.
That I'm going to kick him from the case.
Yep.
Oh my gosh.
Well, and the other fun thing is that right after he gets involved in all of this, he's like, screw it, I'm becoming a road worker.
I would too, man. Just let me out of the case. Let me be my road worker. Let me work the roads in peace.
I kind of am reminded of the movie Office Space, where the main character, like his
Yes,
win condition is
yes.
he becomes a road worker.
Oh my gosh, yes. And he's like so happy working that job.
Yeah, I'm just like, that's kind of what we're dealing with here. He's just like, screw it, I'm gonna go, I'm gonna build road. Like I'm gonna
Please tell me that one of the writers to Office Space was Canadian.
I'm gonna say yes, just because I hope that is the case. I don't know if that is. I'm just making that up. But now we can look at Moncrief and his ruling, because he keep in mind he just lost on this before. Like he was just overturned. So now, as you said, he's coming out swinging, going, I want to not get appealed this time. So he says, I'm unhesitatingly of opinion that those who deal with the production of food or produce fluids for beverage purposes, come, like how overwrought could it be? Ought not to be heard to plead ignorance of the active danger which will be associated with their products as a consequence of any imperfect observation of cleanliness at any stage in the course of the process of manufacture.
Pause
like,
and
when
explain.
mice or snails can get in.
You have to explain. Moncrief is basically saying, I don't buy the argument that the workers aren't seeing and aren't responsible for at least checking the bottles.
Yeah, that you can just say, oh, well, I didn't know there were any mice in here. Oh, well, tough, right? So, yeah, he's like, that's some crap. He says the danger of infection is such as is or should be known in every domestic kitchen and still room. And
Yes.
I feel like at this point they already knew enough about food safety, right? You knew that you have to not, contaminate your food. Tainted food, when offered for sale, is, in my opinion, among the most subtly potent of dangerous goods, and to deal in or prepare such food is highly relevant to infer a duty. I fail to see why the fact that the danger has been introduced by an act of negligence and does not advertise itself should release the negligent manufacturer from a duty or afford him a supplementary defense.
Lord Moncrief.
Yeah, when you think about it, I mean, in some ways, this is more dangerous. I'm probably more likely to get killed statistically by a bad sandwich than I am working on fireworks displays.
Well, and the thing is, this is a trial judge. So this is the judge that you can tell by his writing does trial work. He is listening to these cases. He's hearing these people, and he's speaking to an appellate court, which is one step removed, where all they're reading are pleadings. They don't see the people. They don't understand the facts on the ground. So this is a trial judge that's basically writing to the appellate court saying, look, I know you guys think you guys are amazing and you guys are always right. This is serious. I see a lot of these cases, yada, yada. Like I see food poisoning cases. I see this. Take this seriously. Don't just dismiss it out of hand. And he writes this long paragraph to them basically saying, I'm not going to let you jump over this like it doesn't exist.
Yeah. And he says, whether such products should or should not be classed as dangerous goods, I am in any event of opinion that it is a wrongful act to sell in order that others may purchase and consume articles which have been exposed through negligence to a practical risk of contracting a dangerous taint. Chat, stop it. I know where chat is going on that.
You did that. I had nothing to do with that whatsoever.
But, I mean, to our modern sensibilities, this makes perfect sense, right?
Yes.
But at the time, this is him crusading to to change the rules, right? To overturn the status quo. This is him leading. He's tilting at windmills right here.
Yep.
So, yeah. So Moncrief's ruling in Donahue and Stevens is appealed. And it's heard by the same panel that appeal
No.
Mullen. So if you're judge shopping, this is the least shopping judge shopping you could possibly do, because he gets the same panel. Now, I'm just going to say he does better with this panel. He gets, I think, a 3-4 ruling against him. One of them rules in, like, one of the panel rules for there being a claim. But they had opinions. Real opinions. Because can you imagine, like, you are in a court of appeal, you've just issued this ruling 3 weeks prior, and these impertinent creatures are coming before you with exactly the same argument. You can think of how they were, how they'd phrase that. So they say, now the only difference, and so far as I can see, it is not a material difference between that case and this case, is that there we were dealing with a mouse in a ginger beer bottle, and here we are dealing with a snail in a ginger beer bottle. Quad ultra, the circumstances appear to be identical. And they carry on to say, now, my lords, if the opinions which were expressed by Lord Ormadal and Lord Anderson be sound, and if the opinion which I at any rate indicated, if I did not clearly express it, be sound, then it follows that the conclusion which the Lord Ordinary sounds like a contradiction and a half, arrived at in this case, namely that a proof is necessary, was a wrong conclusion. His lordship held that the plea to relevancy tabled by the defenders was a bad plea and repelled it. If the views which I have expressed are sound, that plea ought to have been sustained and not repelled. We have been invited by Mr. Milligan to reconsider the views which were expressed in Mullen's case and to which I have drawn attention. I am bound to say that having reconsidered the whole matter in light of the cases to which reference was made on that occasion, and on this, having read with attention the Lord Ordinary's opinion and having listened with care to the argument propounded by Mr. Mulligan at the bar, my opinion remains unaltered. My view is that the averments of the pursuer, i.e. the arguments, are, in this case, are irrelevant. And so irrelevant just means basically we're dismissing them. This is also the Lord in this one going on to say, I think it unnecessary to detain your lordships, i.e. the other members of the panel, by going through the cases for a second time, seeing that they were so fully canvassed on a recent occasion in this division. I will only say that, if my view be right, it would seem to be unnecessary to go into the facts of the present case at all.
Wow.
So, Lord to English translation, did we stutter?
I like this. I like this. Good way of basically taking that argument of a bunch of legalese and boiling it down to like one sentence, like, excuse me. No. look again. Just one more time. Look again. You missed the point. You missed the point.
Yeah, we already told you to go away. Yeah. And apparently Lord Ordinary is a title, not a name. That's even worse. What title is Lord Ordinary?
Are you kidding me?
So then they want to appeal it even further.
I like this one. Lord Ordinary, Earl Mediocre, Duke of Irrelevant.
So,
all right, so we're going higher. We're done with this. They're going to get it wrong. 10 out of 10. Let's keep going.
They're going to go up to the House of Lords, which is the Supreme Court equivalent. And they've got some additional lawyers, George Martin, King's Counsel, and William Milligan for Mrs. Donahue.
Mm-hmm.
Milligan later becomes Lord Milligan. And he's working for free.
Good for him.
Her lawyers are working for nothing at this point. And how many lawyers do you know?
Well, they see the principle. This is what happens with Supreme Court cases. with Supreme Court cases, they call them test cases or staged cases, and the worst is the media tries to play them off as being less significant because of their staged nature, because it is meant to test a legal principle. You have to have the right set of facts to make the judges consider the right law and the right outcome. And sometimes it takes some maneuvering.
Yep.
What was it? Plessy v. Ferguson.
Yep.
Famous US case. That was completely staged. Everyone knew what was happening. They all knew. And the attorneys, they weren't asking for money. They had that funded separately. That was separately funded.
Sometimes it's not even that it's separately funded. Sometimes it's just that they're like, we believe in this. That happens. The other thing is that they might say, listen, we think this case is going to be historic.
Yep.
And we'll run it on that basis. Like if you had, if you knew what Brown v. Board of Education was going to be, if you send me back in time, that's a case I'd run for free. Right? There's all sorts of cases like that where it's just like, I'd run this for no money just to have my name on that decision.
Because you know the legal principle is right. You know what you're arguing about is right.
Yeah. So that's what I think that they're here for. Stevenson.
Exactly. Yes. You know the principle you're arguing for is right. You want to overturn it. You want it to be corrected. So you take that case, not for anything, but because you want to be a part of this movement.
And Stevenson also has a rock star team. He's got Wilfred Norman King's Counsel, who later becomes a law lord, which is apparently a thing. That sounds like a D&D class.
Law lord. Lord of laws. I am Lord of laws. Law lord.
And James Clyde, who becomes Lord President of the Court of Session, which means he runs it. Like he is he's the top judge there, basically. Now, Clyde had also appeared on Mullen.
What the hell? Okay, so they know the case. You know what? Good. They know the cases. They know the law. They are well briefed. They are the best parties to argue this case again.
But it really feels like a showdown. This feels like a sequel, right? They're back for another show, Friday the 13th, part 2. They're back to fight again. Yeah. So they have 2 days of hearings, for which there are, so far as I can tell, no transcripts. And they get a 3-2 decision after a 5-month delay. Takes them 5 months to decide on this one, which tells me that they were probably arguing a lot. This was probably hotly contested. There was a lot of argument here. And so we've got a bunch of different rulings. We'll start with Lord Buckmaster. And Lord Buckmaster would have ruled for
Sorry,
Stevenson.
I heard that wrong. That's my maturity. I'm sorry. That's my maturity. That is my maturity. I am sorry. I read that entirely wrong, and I apologize for my immaturity.
Fair enough. Let's not ask what you were thinking.
Nope.
But he votes to throw out the claim. And his main concern is that he wants to he's concerned that everyone's going to start suing everyone. So he says it may be noted that it may be noted also that in this case, Alderson B said the only safe rule is to confine the right to recover, i.e. the right to sue, to those who enter into the contract. If we go one step beyond that, there's no reason why we should not go 50.
This is the Stephen Breyer, the Parade of Horribles. My God. Okay. So this is the U.S. Supreme Court's Justice Breyer was notorious for this argument of the Parade of Horribles. Let's
Yeah.
take this principle of law and apply it to its logical extent. Like go the furthest extent of this principle of law. And it's the parade of horribles argument to say, if you change the law, these are the horrible outcomes that will come from this change in the law.
Well, and also, like, it's a slippery slope argument.
Yes.
If we allow this claim, then we have to allow the next claim. Then we have to allow
And the next
claim,
one, and the next one.
and the next one. And that's not what happened.
No.
We're actually going to get to Lord Atkin and how he narrows this down, right? Because clearly you can't sue everybody for everything.
No,
right?
And that's not the principle being argued for. Because the other thing is, Lord Buckmaster, I can fight back on this no problem. Look at the reverse of this. How many cases are there where someone is seriously injured that's a pure innocent victim, like a child, like the kids of a family?
Yeah.
And they have no recourse whatsoever. That cannot be what the law intended. So there has to be a middle ground.
It just feels so wrong, right? For this guy, like Mullen's kids can't recover because they didn't buy the ginger beer themselves.
Right.
It just like that feels terrible as an outcome.
Yes. That cannot be what the law intended.
The law really tells us that we should not be like the law should never be spitting out these rulings where we just go like, that is crazy, right? That is, and that's what it was doing here. So,
well, and this is an interesting point because I want to do a caveat here. So honk banana, no. Well, then you should probably write better laws. Okay, here's the problem. Right now, we're in English common law. This is English common law. This was not interpreted under statute, correct? This is just straight contract law interpretation.
Straight common law, yeah.
Yep. So common law is basically just the law of the land that is known because it is law that is, it's common. It's just, it has been passed on and passed on and passed on and developed upon. It is understood to be the foundational principles on which we make decisions. So there's common law and then there's statutory law. If there's a statute on point, you follow the statute. This is not statute. There is no statute that we're interpreting. This is common law. So this is trying to make a change in our fundamental understanding of the law.
Yeah. And, and it's an important case, but there's, he quotes from Mullen. So he's quoting, the decision that, we don't like, which says, in a case like the present, where the goods of the defenders are widely distributed throughout Scotland, it would seem little short of outrageous to make them responsible to members of the public for the condition of the contents of every bottle which issues from their works. It is obvious that if such responsibility attached to the defenders, that it might be called on to meet claims of damages which they could not possibly investigate or insure. If you have to say that every bottle is mouth free, how could you possibly defend against that? And I'm going, by modern standards, we do expect every bottle to be mouth free.
It's not that hard. The contractor or the employee just has to, take like a glance inside the bottle, not just look through the glass. Like just shift like a little bit and you can see.
Hold it up, have a strong light that you can put it in front of and look, whatever it is, right? So
like cool things that we can do to figure out if there's a snail or a mouse in the bottle.
And now we get to Lord Tomlin, who notes that he agrees with Lord Buckmaster in every respect. But he goes on to say some other things, and some of those things are going to be shocking. You're going to hate some of the things he has to say. He says, first, I think that if the appellant is to succeed, it must be upon the proposition that every manufacturer or repairer of any article is under a duty to everyone who may thereafter legitimately use the article to exercise due care in the manufacture or repair.
I need my F-bombs.
Which is like, no kidding. It is logically impossible to stop short of that point. There can be no distinction between food and any other article. Moreover, the fact that an article of food is sent out in a sealed container can have no relevancy on the question of duty. It is only a factor which may render it easier to bring negligence home to the manufacturer. So he says, listen, if you allow food manufacturers to sue, then you also, for instance, have to allow a car manufacturer to sue if they send out cars with brakes that suck. To which, in the modern era, we say, good, right? We say good. That makes sense to us.
Like, oh, the bleeping horror that, you know, we might actually say that a person who manufactures a product that they know is going to be used by someone that could be injured by it should at least be aware that the duty that they have to make the product would extend to the person who might use the product.
Well, and he goes on to offer a specific example.
Oh, no.
The alarming consequences of accepting the validity of this proposition were pointed out by the defendant's counsel, who said, for example, every one of the sufferers by such accident as that which recently happened on the Versailles Railway might have his action against the manufacturer of the defective axle.
Oh, you don't say.
So let's talk about the Versailles rail accident.
All right, one of these is getting tossed. F-bomb, there it goes, boom. Oh,
So-
because we're not. Oh,
What happened in this accident is that a faulty axle, and this was in part because they didn't understand metal fatigue. But regardless, the manufacturer of this axle, the axle fails. And when the axle fails, the train derails. And trains in that era had, you know, an engine that was based on like coal and fire and so forth.
coal and fire, yes.
So
And there was a coal car immediately behind the engine.
So the coal car spills, the engine spills flames, and the passenger cars come to end up over top of coal and flames. And they catch fire.
Yep.
And the practice at the time, which is not the practice now. In fact, it's not the practice now because of this incident. But the practice at the time was that you would lock every pedestrian car, like every passenger car, sorry,
From the outside.
from the outside when you loaded it.
Yep.
So everybody on this train was locked inside.
Mm-hmm.
And there was fire.
Mm-hmm.
And when you think of places you want to be when there's fire, locked inside the train car that is on fire is like
With wood
last on the list.
Inside the train, wood and fabrics that are probably very, very flammable.
Yeah, they
With
probably
coal.
haven't invented like you know, flame resistant coatings and that kind of thing.
Yeah. Yeah.
So between 50 and 200 people died. And the reason why they can't tell is because A, they didn't
you don't have
keep
to
great
say it.
records, but B, the fires were real hot.
They were too hot.
And so this lawyer makes the argument of, could you imagine if every one of those people could sue?
Why yes. Why yes. Why yes. Why yes I can.
I'm
Because
like,
if I'm manufacturing an axle for a train that is meant to transport humans, I can reasonably foresee that a fault in that axle will result in the injury or death to the humans being transported by that axle.
yep.
Yes.
It's nowadays we go like, no kidding, everyone can sue because they got burned alive. That seems like a thing you'd want your next of kin to sue over.
Yeah.
Um,
Heaven forbid that we allow the quote unquote poppers to sue for a defective product that resulted in the death of so many of the poppers.
I mean, if I get burned alive due to somebody's negligence, my wife is expressly instructed to sue the shit out of them.
You're not allowed to be burned alive because you have to be cremated because I need to send the ash to somebody.
I'm
Inside
like,
joke. Inside joke,
there's a
folks.
number of options on that one. Yes.
Inside joke.
Yep.
Sorry.
Chat will tell you later. So Lord Atkin, and Lord Atkin really is the one who leads the charge on this one. His position is the one that gets quoted most later on. And so he really delivers a speech in favor of Ms. Donahue's claims, or Mrs. Donahue's claims. So he says, the question is whether the manufacturer of an article of drink sold by him to a distributor in circumstances which prevent the distributor or the ultimate purchaser or consumer from discovering by inspection any defect is under any legal duty to the ultimate purchaser or consumer to take reasonable care that the article is free from defect likely to cause injury to health. I do not think a more important problem has occupied your lordships in your judicial capacity, important both because of its bearing on public health and because of the practical test which it applies to the system of law under which it arises. And I'm just going to note here, like, he put some brakes on this, right? He doesn't say every manufacturer of a foodstuff is liable for every injury. But he does say, like, if the person who picks it up can't tell, then you're on the hook.
So here's like boiling down his speech. You have the manufacturer, right? Sold to the distributor. Okay. And the way the sale was conducted was such that the distributor wouldn't be able to tell. The distributor couldn't tell. When the distributor received the bottle, the distributor could not see the snail in the bottle. Okay. Manufacturer had power and possession over that. They had the ability to do it. Distributor can't see it.
But like this wine bottle,
you can see
clear.
Yep.
And if I buy this and it's got a mouse floating in it and I decide to drink it, that's on me. Because at that point, it's probably just that I'm into mice.
Yep. Like, and if you're the distributor and you receive that from the manufacturer, you can see it before you serve it to a customer.
Yeah. I mean, like if my liquor store is putting this on the shelf and they set it down, they're like, oh, hey, that's a mouse in there. Yeah. They can be like, we're just going to take this away and not sell it to a customer. Yep. So all sorts of, all sorts of rules there, but it puts brakes on it. It doesn't say that everyone is, on the hook for everything.
Yep. It says responsibility. It basically says common sense has to be employed at every stage of this.
Yeah. And he goes on, he says, but acts or omissions which any moral code would censure cannot in a practical world be treated so as to give a right to every person injured by them to demand relief.
There's the limits.
In this way, rules of law arise which limit the range of complaints and the extent of their remedy. The rule that you are to love your neighbor becomes in law, you must not injure your neighbor. And the lawyer's question, who is my neighbor, receives a restricted reply. This is archaic, but it's kind of poetic.
It's beautifully written, actually. Like I'm a fan.
I could listen to this guy deliver speeches like all day.
This is like Clarence Darrow.
He says, you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. Who then in law is my neighbor? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I'm directing my mind to the acts or omissions which are called into question. And that makes sense, right? That's really crystal.
What a beautiful way of saying it too.
So like, I got hot sauce that I'm planning on eventually getting, sold to whatever, right? I can contemplate that somebody's going to eat the hot sauce.
Yep.
I probably can't contemplate that somebody is going to use the hot sauce to shave.
Or fuel their car.
Or fuel their car. Or that they're going to, somebody's going to try it as lubricant. And I don't mean like motor vehicle lubricant.
Ian. Oh.
Those people who are doing weird things with it are not my neighbor in this sense, because I can't really contemplate reasonably that someone's going to do that.
Well, let's take it to the most simple conclusion. Go back to the Mullen case, right? And then the hypothetical I gave. I see a family walk into my restaurant. I can reasonably expect that every person that walked into that restaurant is going to eat the food that I'm going to prepare for them.
Yeah.
Regardless of who pays for the bill, I can reasonably anticipate that the food I serve is going to be consumed by everyone sitting at that table. So my duty extends to those people that I can reasonably foresee consuming the food I'm making.
Yeah. And, same thing if you're just selling. Like if you're selling ginger beer, you have to reasonably foresee that somebody might drink your ginger beer.
Yes. And it might not be the person you sold it to. It might be someone else who consumes it down the road.
Yep. And, and so we can get other, we can apply this to other contexts. Let's say I'm a manufacturer of cars. Well, somebody's going to drive this car. Somebody might be a passenger in this car. And even somebody might be a pedestrian on the street. Because, if I sell this car and it has no brakes, it has non-functional brakes, it could be that a pedestrian gets killed. And
that's foreseeable.
Yeah, all of that is you can expect this to happen. But let's say it turns out that this car happens to be really dangerous if you get underneath the car and saw out the catalytic converter.
Okay. But I'm not anticipating that someone's going to get out of the car and saw out the catalytic converter.
Right. This is now you're looking at crime, where you're sitting there going who's actually predicting that someone's going to do this? And I didn't intentionally make it dangerous. I just didn't think that anyone would be stealing catalytic converters. Maybe it was before that was a big deal, right? So yeah, it's you just don't know, right?
But Atkin has a lot more to say.
Oh, he's
a lot more.
He's got a lot to say, and I can only go through some of it because he wrote a long decision. So Lord Atkin, but in the class of case now before the court, I cannot conceive any difficulty to arise. A manufacturer puts up an article of food in a container which he knows will be opened by the actual consumer. Because of course the container is not going to be opened by the retailer, right? If I, when I go to the liquor store and buy a bottle of scotch, I don't want the liquor store opening each bottle of scotch to inspect it. In fact, that would really piss me off, right? So, yes. And that was part of the joke, because, yes, I did.
Yes, that was the joke.
He says, there can be no inspection by any purchaser and no reasonable preliminary inspection by the consumer. Negligently, in the course of preparation, he allows the contents to be mixed with poison. It is said that the law of England and Scotland is that the poisoned consumer has no remedy against the negligent manufacturer.
Oh, God, I love this judge. So he just went to the logical conclusion on the other end.
Yep. He says, my lords, if this were the result of the authorities, I should consider the result a grave defect in the law and so contrary to principle that I should hesitate long before following any decision to that effect, which had not the authority of this house.
Wow. I'm not going to follow it unless it comes from this house. And even then, I'm going to doubt it.
Yeah, it's like, I understand that this is the authority, but it's stupid, and I'm not going to follow it.
Yep.
Says, I would point out that in the assumed state of the authorities, not only would the consumer have no remedy against the manufacturer, he would have none against anyone else.
Yep.
For in the circumstances alleged, there would be no evidence of negligence against anyone other than the manufacturer, and except in the case of a consumer who was also a purchaser, no contract and no warranty of fitness, and in the case of the purchase of a specific article under its patent or trade name, which might well be in the case of the purchase of some articles of food or drink, no warranty protecting even the purchaser consumer.
Yep.
He's like,
So this
you guys,
is, yeah.
He's saying you guys have set up a rule that says that nobody's at fault.
Yep. If you are saying that basically like an aggrieved employee that slips arsenic into the bottling.
Yeah.
The aggrieved employee does this, right?
And your kids drink it and die.
Yep.
There is no claim.
Nothing.
Like,
or that like some practical joker on the assembly line takes a stale and puts it in the bottle.
Or just they're really sloppy. It's like we've got a factory that produces rat poison and also produces fine scotch. And sometimes one gets in the other. You know, like...
Okay, I'm with you.
Well, I mean...
it's a good hypo.
The more classic example is you've got a factory that might produce candy, but also bags nuts. And,
yeah. And then you've got
and then they don't label their packages as caution may contain nut fragments or whatever. And so somebody picks up like a chocolate, which, or like a gummy or something, and they eat that, and they don't realize that like down the same conveyor belt an hour earlier were walnuts, and they end up, dying. And I'm going, and it's like, oh, you can sue nobody for this? Like, yeah, it's ridiculous.
Yep.
All right. So, he says, my lords, I do not think so ill of our jurisprudence as to suppose that its principles are so remote from the ordinary needs of civilized society and the ordinary claims it makes upon its members as to deny a legal remedy where there is so obviously a social wrong.
Can I translate?
Yes.
Can I translate? You're not this dumb.
Yeah, it's like...
You're not this dumb.
I feel like that's a good translation here, right?
It is.
Like, we can all see that this is wrong. Can we not, like, just say that? Like, you guys have your heads so far up your butts that you are failing to recognize that this is obviously stupid, right? And he goes on to say, my lords, if your lordships accept the view that this pleading discloses a relevant cause of action, you will be affirming the proposition that by Scots and English law alike, a manufacturer of products which he sells in such a form as to show that he intends them to reach the ultimate consumer in the form in which they left him, with no reasonable possibility of intermediate examination, and with the knowledge that the absence of reasonable care in the preparation or putting up of the products is likely to result in the injury of the consumer's life or property, owes a duty to the consumer to take that reasonable care.
There's the principle of law.
Yeah, that's the principle of law, and it feels so obvious to us now, right?
Yes.
So Lord Atkin basically, in some ways, he sounds like he is saying nothing at all, because what he's saying is super obvious now.
Common sense.
This has been so integral to how our society functions now that it's just like, yes, this is obviously the case. But we have some concurring views. Lord Thankerton.
Well, we're not thankful for him.
Well, this guy is agreeing. He says, the present case is that of a manufacturer and a consumer with whom he has no contractual relation, of an article which the manufacturer did not know to be dangerous, and unless the consumer can establish a special relationship with the manufacturer, it is clear, in my opinion, that neither the law of Scotland nor the law of England will hold that the manufacturer has any duty towards the consumer to exercise diligence. In such a case, the remedy of the consumer, if any, will lie against the intervening party from whom he has procured the article. I am aware that the American courts, in the decisions referred to by my noble and learned friend Lord Macmillan, have taken a view more favorable to the consumer. In fact, the U.S. courts got to all of this
way before this,
like
way
5-10
before
years.
Yeah.
And in fact, they were arguing U.S. precedent in the British courts on this,
which is weird. That's weird.
Is.
That is so weird because our courts were based on English common law, and for our courts to reach this principle and for them to take that logic and reverse it, that had to just not taste right for the House of Lords.
And I feel like there was some anti-Americanism in the reasoning when they were
in the reasoning
those cases.
It had to be because they're like, we're not going to side with the Americans.
Yeah, we're going to have our different rules over here. But he bases his decision heavily on the fact that it's opaque glass.
Oh.
He says the present case is that of a manufacturer and a consumer with whom he has no contractual relation, of an article which the manufacturer did not know to be dangerous. That's the same paragraph. There we go. He says the special circumstances from which the appellant claims that such a relationship of duty, should it be inferred, may, I think, be stated thus vis-a-vis the respondent. In placing his manufactured article of drink upon the market, has intentionally so excluded interference with or examination of the article by any intermediate handler of the goods between himself and the consumer, that he has of his own accord brought himself into direct relationship with the consumer, with the result that the consumer is entitled to rely upon the exercise of diligence by the manufacturer to secure that the article should not be harmful to the consumer. So basically, he's making a special argument here. He's saying essentially that, like, if you can see inside the bottle, because it's a clear bottle, then I would sue the liquor store if this is a problem, because the liquor store had a duty to examine it. Or if I went to a restaurant and the restaurant poured, they saw that there's a mouse in it and they poured it into my wine glass anyway and deliver it to me. And only after I get sick, I go back and the waiter's like, oh yeah, I'm not surprised you got sick. There was totally a mouse in that bottle. Then in that case, it's like, I can't sue the manufacturer, even though the manufacturer was how the mouse got in. I'd have to sue the restaurant, is basically what he's saying. But if I go in and I buy this thing and, it comes to me in a sealed bottle that I can't examine, now because the liquor store or the restaurant or whoever else has been excluded from that pattern, now I can sue the manufacturer. That's kind of where he's coming at this from.
Oh, so I looked it up. Do you want to know how? Let me see. We decided the product liability stuff. It became ingrained in U.S. law and precedent in U.S. law in 1913, and then affirmed by the Supreme Court in 1916.
Yeah.
So about 10 years before.
So,
sorry,
I mean,
got distracted.
And this is important, right? The U.S. got there first on this one. It was, and it kind of feels like so obvious.
But there was a back and forth. What was cool is that era, because I was just looking this up, that era of the late 1800s and early 1900s, the U.S. courts and the U.K. courts were going back and forth on this. one would extend, the other one would pull back, the other one would extend, and you saw this back and forth, and they were arguing with each other in just their own opinions. They knew they weren't speaking directly to each other, but they wrote in such a way that the other courts would see it.
Yeah, and Canadian law, in fact, will sometimes refer to U.S. law, and sometimes will refer to U.S. law and say, we're going to follow this. It worked out great in the U.S. And sometimes Canadian court cases say, hey, look, this is the rule in the U.S. and it sucks there, so we're not doing that. So it's kind of an important back and forth there.
Yep.
All right, so that's Lord Thankerton. Now we get to Lord Macmillan. He also rules for Mrs. Donahue because this is a 3-2 split. And he relies on this reasonable person notion. Now, reasonable person is this concept that ends up in the case law everywhere. And
the reasonably prudent person.
Yeah, it's like if you get into a car accident, the test of how you're driving is going to be the reasonably prudent person. Now, who is the reasonably prudent person? Literally no one on the planet.
Correct. Thank you for saying that. Please say it louder for the people in the back. There is no such thing as a reasonably prudent person because we're all idiots. Everyone's an idiot.
Oh, everyone is an idiot. We all fall short of it. Like literally all of us. Because the reasonably prudent person is basically reasonable all the time, whereas most of us are not. I have burn scars on my hand because I did a dumb thing. When you drive, if you ever if you ever get tired and you keep driving, that's not being a reasonably prudent person.
Or if you glance at your phone, not texting, if you glance at your phone, that's not reasonably prudent.
Your kids are in the back seat and one of them hits the other one and you lean back to say, stop it. The reasonably prudent person would let your kids keep hitting each other and pay attention to the road. Like the reasonably prudent person is kind of a myth. Nobody is actually a reasonably prudent person at all. You can come close, but
we try to put that buffer in there because you want the jury to say, what would I have done in that circumstance? Because the jurors are going to think in their head, I'm a reasonably prudent person.
And keep in mind, the jurors are always going to think that they're more careful than they are.
They always do.
If you ask a group of jurors how fast they go in traffic, they say the speed limit. Whereas if you actually look at how fast they go in traffic, it's 5-10 over.
Well, I totally would have seen that car coming through the intersection.
Yeah, I totally would have seen the car. I would never have turned to, tell my kids to knock it off. But I mean, you still do get situations where even the reasonably prudent person might have a problem. So, for example, let's say I'm driving down the road and I've got my window open because it's a nice sunny day. And some little shit of a kid decides that he's going to, this is the day he's going to play a prank, and he lobs something in my window. Maybe he hits me in the face with a water balloon. Maybe he lobs a beehive, like he's found a wasp nest, and he just chucks that into my car, and I get like wasp nest to the face. And maybe I end up crashing into somebody's like parked car because somebody threw a wasp nest in my face. We kind of think that the reasonably prudent person is still vulnerable to having a wasp nest chucked in their face. Stuff like that happens. Let's say I'm driving down the road and I've never had a health condition before, but I have a heart attack. And it leads me to end up in the oncoming traffic lane. I hit a car.
Yep.
But it's because I had a heart attack. Well, we all recognize that like any of us could have a heart attack, and it might not necessarily like it doesn't call ahead and book an appointment. Like, hey,
No.
is Wednesday at 3 in the afternoon a good time for a heart attack for you? Because I'd just like to pencil you in our calendar. It's not how that goes.
Well, and
So
the thing with that is it's this is where it comes down to the lawyers and why this is why jury deliberations are private, because you have to allow the jurors to process this information in private in their own heads, applying their understanding. That's why we have that standard. They
yeah,
have to be able to listen in and think in their head, how would I have acted under these circumstances? And that's also why lawyers are important, because the lawyers are there to, the fear element. How would you have acted under fear or duress?
yeah.
How do they understand that if not for the lawyers arguing and telling them this is the circumstance? They're storytellers. So,
Well, I mean, another example. Let's say I'm at my house. Somebody comes to the door and they've got a shotgun and they start shooting through the door and trying to kill me. I grab a rifle and I fire a shot back and I miss the dude and it goes across the street and kills my neighbor.
Yep.
It might be that the ordinary person in that circumstance of somebody's shooting at them, trying to kill them, might not make the best decisions, right?
Yep.
And might not have the best aim, right? And it's just all of these things are things we got to consider. So Lord Macmillan is really going hard on the reasonable person. And says, if on the other hand you disregard the fact that the circumstances of the case at one stage include the existence of a contract of sale between the manufacturer and the retail, and approach the question by asking whether there's evidence of carelessness on the part of the manufacturer and whether he owed a duty to be careful in a question with the party who has been injured in consequence of his want of care, the circumstance that the injured party was not a party to the incidental contract of sale becomes irrelevant, and his title to sue the manufacturer is unaffected by that circumstance.
There you go.
Listen, you guys are all getting bogged into contract stuff.
Yep. Principle.
Contract is a red herring. The principle is carelessness, and carelessness fundamentally is a reasonable person thing. Like, what is it to be careless? Well, to be less careful than the reasonable person is basically what that translates to. And he says, whenever one person supplies goods for the purpose of their being used by another person under such circumstances that everyone of ordinary sense, again, we're talking about the reasonable person here, would, if he thought, recognize at once that unless he used ordinary care and skill with regard to the condition of the thing supplied or the mode of supplying it, there will be danger of injury to the person or property of him for whose use the thing is supplied and who is to use it, a duty arises to use ordinary care and skill as to the condition or manner of supplying such thing. And for a neglect of such ordinary care or skill whereby injury happens, a legal liability arises to be enforced by an action for negligence. Ordinary care and skill, again, is reasonable person, right? That's what that comes down to.
I mean, the principle here is it's not that hard to look into the bottle and see that there's no snail in the bottle. Are we expecting that much of people?
A reasonable person would check their bottles for snails, mice, rats, weevils, whatever might be in there, dirt,
before filling it with a product intended for human consumption. That's the other caveat.
Exactly.
I am serving a product intended for human consumption. I should make sure that the bottle doesn't have something that me as a human doesn't want to consume.
I mean, when I make pickles, I wash the bottles, wash out the jars. And, I would certainly not make pickles with that jar if there was a dead mouse in it.
No.
And I sterilize the jars, right? So it's you're gonna take that care and attention.
But the judge isn't even going that far. He's not that's the thing. He's not even going that far. That's why I don't understand how this isn't already a principle. Is the judge is basically saying, look in the bottle. Just look in the bottle. Just look in the bottle. Look at the stupid bottle.
Like a reasonable person would check the bottle. He says the law takes no cognizance of carelessness in the abstract. It concerns itself with carelessness only where there's a duty to take care and where the failure in that duty has caused damage. In such circumstances, carelessness assumes the legal quality of negligence and entails the consequences in law of negligence. What then are the circumstances which give rise to in this duty to take care?
Okay. When are we going to impose the duty? When does the manufacturer have to use a little extra before selling?
How do you know when you have a duty? Because, like, if I'm just selling bottles to, let's say I'm selling bottles to a glass recycler, and I know that the glass recycler is going to crush these bottles up and melt them down and make new bottles.
Yep. I do not owe a duty for human consumption. Nope. Because really I'm selling it to be crushed.
Exactly. And, you know, if I know that this bottle is dirty, oh well, right? Like, nobody's going to be concerned by that. But if I'm actually putting food in it, that's another thing there, right? So he says the criterion of judgment must adjust and adapt itself to the changing circumstances of life. The categories of negligence are never closed. The cardinal principle of liability is that the party complained of should owe to the party complaining a duty to take care, and that the party complaining should be able to prove that he has suffered damage in consequence of a breach of that duty.
So freaking common sense.
He says basically this is going to be flexible and it's going to be based on the circumstances. I mean, another example. Let's say I leave some bottles out and they're full of like horrible gunk. Like, I was just using these bottles to like clean out the sewage tank of an RV.
Can you pick something that's less just
No, that's not how my brain works. My brain goes to the
most
weird
extreme
examples.
What if there's spicy gelatin? The ignited
gelignite.
Yeah.
So, but then I leave these bottles outside my house because, you know, in a couple of weeks I'm going to take them off to get disposed of.
Okay.
And somebody comes onto my property and steals the bottles and fills them with water and drinks them. Do I owe that person any duty of care?
No, they stole the bottles.
No, they stole the bottles. They didn't.
They used it for a purpose that you hadn't intended. There's no way that you can anticipate that someone's going to steal your bottles, fill them with water, and drink out of them.
And there's just no way to expect that this would be the case. Meanwhile, if somebody says, hey, I need a water bottle. Can I have one of those? I'm going to drink water out of it. And I go, sure. Then now I'm back into, I owe this person some, I owe this person, right? Because now I know that they're going to be drinking this. So it's basically, you can't fully decide where negligence applies. You have to do this case by case under the circumstances.
Yep. So McMillan goes on.
He goes on and he says, now I have no hesitation in affirming that a person who for gain, you're making money doing this. This is your business. Engages in the business of manufacturing articles of food and drink intended for consumption by members of the public in the form in which he issues them is under a duty to take care of the manufacture of these articles. Mm-hmm. That duty, in my opinion, he owes to those whom he intends to consume his products, i.e., not just, the ultimate buyer of it, but whoever is going to drink it.
Yep.
He manufactures his commodities for human consumption. He intends and contemplates that they shall be consumed.
Surprise. Wow. We are shocked. We are shocked. We are all shocked.
Yeah. By reason of that very fact, he places himself in a relationship with all the potential consumers of his commodities, and that relationship, which he assumes and desires for his own ends, imposes upon him a duty to take care to avoid injuring them. Like, you can't injure the people who are going to be drinking your stuff. Is just such a.
You have to avoid the dangerous taint.
Yes.
We have come full circle.
Dangerous taint is one of my new favorite legal quotes.
You have to avoid the dangerous taint.
I might have to make that into a shirt.
You have
the dangerous taint.
Just avoid the dangerous taint.
Yeah.
Okay. Sorry. Continue.
He owes them a duty not to convert by his own carelessness an article which he issues to them as wholesome and innocent into an article which is dangerous to life and health.
Yeah. You sold. Hang on. Excuse me, sir. I ordered a salad. This is brick.
Yes.
Yep. Now we have reached the I ordered a salad. You have served me brick.
So she wins at the House of Lords.
This is the part where I hate you.
But she hasn't won the case yet.
I know. This is the part where I hate you. And this is the part where I hate this case. I hate that you chose this case. This is the part where Rob gets traumatized.
Because this was just like she wins the motion of dismiss. Like, the motion to dismiss. Basically, that motion to dismiss goes up to the Supreme Court. And so after that, she is entitled to pursue the case.
Yep, she can go for trial. She can go for trial. We can have a trial on the facts.
Yep.
All those things that were denied, we can now try to prove them.
Fundamental questions like, was there ever a snail? Are things that we will now decide. Except Mr. Stevenson drops dead of bowel obstruction. November 12th, 1932.
Mm-hmm.
And so his estate settles for a reported £200. So let's say somewhere around $15,000 to $20,000.
Yep.
Because his estate doesn't want to be stuck in litigation, right? And his estate is now also in a very difficult spot because his estate needs a certain witness to testify, which is Mr. Stevenson.
Who is not alive.
How is he going to testify to all the precautions he takes to keep snails from getting into his bottles when he's not around? Short of a Ouija board, this case has some problems. So as a result of this, the facts of the case are never litigated, and we never find out if there was actually a snail. And there has been substantial dispute as to whether there's a snail. Mrs. Donahue dies in 1958 at Gartledge Mental Hospital. And as a result of her activities, everything that she fought for is now taken as super obvious.
Mm-hmm. Wait, now we can understand why I was frustrated. You chose a trial of the century.
Where we never actually get the trial.
It was not a trial. There's no trial. There's no resolution. There are no facts. We don't know anything about the outcome, Ian. We don't know anything.
It's the motion to dismiss of the century. And I'm just going to note that there were some serious allegations that maybe this snail never existed. Some of the allegations that have been made is that maybe Mrs. Donahue made this up for her own personal benefit. That was one argument. Another argument is that maybe the lawyers made up the snail and convinced
the test case. They wanted the test case.
Yeah. So maybe they made up the snail and got her involved just as a let's run this through the courts. That's been suggested.
It's 2 hours. This is bullshit.
Yes, we are at the 2-hour mark.
This is bullshit.
That's really, we don't know. We don't know if she ever got sick.
No.
She says she got sick, but we never, that's never been tested.
This has all been resolved on the pleadings. All you have, and what does Emily say all the time? Complaint is God, what did she say? It is innuendo and shade. Is that what it is? Or
I mean, that
allegations
sounds
and
like her.
shade?
Yeah,
Allegations and shade, something like that.
because I mean,
It-
you can put all sorts of things into a complaint that may not end up being backed up. For example, if we look at the Ower lawsuit, I don't know if you've looked at that one at all.
I have, and there's it's allegations and shade, and the thing is, people are making conclusions based on allegations, and I'm saying, wait, just wait. You don't know.
I mean, he says that they did this maliciously because they identified a vulnerable young black kid that they could exploit. And I'm
And
going,
that's possible.
it's possible, but you're probably never going to make that out. That's probably going to be one of those claims that you put into your pleadings, but never actually lands.
It's possible. The thing is, there's one version of events, there's the other version of events. They're both told by both sides, and then there's the truth, which is somewhere in between.
And I
We don't
mean,
know if it's like all the way this way, all the way this way, somewhere in the middle. Allegations and complaints, pleadings, the statements and pleadings are.
I've got some real theories on the Ower case that we should probably chat about on Friday Night Frenzy.
Okay.
Because I think it's it's an example of very much in between the two positions. And that
I think there's a middle ground.
Oh, I mean, this seems like hurt feelings and family dispute. But you can really end up with a situation where but and the other thing I'll note is that sometimes there can be an incentive to overplead. And what I mean by overplead is that
Overpromise.
Yeah, you promise that certain things will be there at the case, and that might get you over the motion to dismiss.
Yeah.
Because the motion to dismiss is based purely on your allegations and not on testing the facts. So if there is an exception to that. The exception is if your facts are basically impossible.
Do you know how many cases that I have at the end of a trial in a divorce case? And this is something I tell my clients beforehand, because they always want to come back with an answer or a counterclaim that is just laying into the other side, just explosive and all these allegations. And I say, don't. Pleadings are promises. And what I do is I begin my closing arguments in cases like that. I begin my closing argument by reading directly from the complaint. I read from the complaint and I read the allegations, and then I stop and say, the evidence on the record proves one or two of the 27 paragraphs that I just read out loud. Yep. And I tell the judge, the court is tasked with assessing the credibility of the parties. The first statement made to the court is the complaint. That is the first statement. That is the way they appear before this court.
Yeah.
That's the benchmark that they have set for themselves. I didn't set it. The court didn't set it. They set it.
I have cross-examined complainants on some of their court filings. Like, hey, you promised this. You said that. That doesn't make sense. Like that. That's not true, is it? Yeah. But this one, in terms of why is it a trial of the century?
Yep.
And it's not the first case to establish this rule, because the U.S. got there first by many years. And one of the big ones was McPherson and Buick Motor Company, where they had a faulty wheel that came off and injured a bunch of people. And they're like, well, you didn't buy the car directly from us, so tough. And
I think that was the 1916 case.
There's a couple of them. There's another one where there was where somebody making a hair product inadvertently put in poison, literally poison got into it. But the U.S. got there first. So it's not that this is the first place where this rule came about. But it did establish it in the Commonwealth. So Britain, New Zealand, Australia, Canada, all of these places rely on this, and you'll see that getting mentioned. It's also a great introduction to legal problems. They teach this in first-year law school throughout the Commonwealth, because this whole thing of like this complicated tangle of contract relationships is a good way to get people to start thinking of the legal concepts, right? Because sometimes you got some legal concepts that you got to deal with, like, and sometimes you have to deal with the fact that, for instance, just because somebody's injured doesn't necessarily mean that they can recover.
Mm-hmm.
And a lot of law students have a hard time with that one.
Oh, yeah.
You know, so as an example,
facts don't care about your feelings. The law oftentimes is not it's not a place for emotion. A lot of places, it's not a place for emotion. It feels like it should be.
I talked to an articling student who said that their first day at the job, they got presented with a hypothetical that was actually from their cases. And they got asked to basically analyze this case. And this included pictures of a child who had been run over.
Yep.
And
once you see those,
it's the kind of thing you don't easily forget. But they wanted to go and work in personal injury. So it's like, yep, that's what we do here, right?
Yep.
And it was basically like, evaluate how much our client can recover on this. And she came out of it being like, I hate that I have to say this, but our client, the parents of this kid, can recover no money on the circumstances of this. And it was basically that this kid had gone and hidden under a car. And they said basically there was no way for them to notice. Exercising reasonable diligence, they couldn't tell that there was this kid under there. It's just a tragic accident. And they're like, yep, that is the correct answer. And we put this question to you so that we know how much we have to babysit you on your cases.
Yeah.
Right at the outset, because you need to understand that just because you're upset has nothing to do with the law. And, you know, in some cases, it can be really, one thing that just absolutely flabbergasts people is things like a cyclist can be responsible to a vehicle driver for the emotional suffering the vehicle driver had from running over the cyclist.
Yep. It's weird.
It happens all the time.
It happens. So too can pedestrians jaywalking.
Yep. If you are running out into traffic and a car runs you over, you might end up owing the car, like the driver, money.
For emotional distress because you caused it.
Yeah, you caused it. It was your fault as the pedestrian or as the cyclist or whatever. And so the consequences of that, even though you came out worse than they did, you can still end up owing them.
Yep.
So this one is a great introduction to legal problems, because when you walk through the law as it existed at the time, the result is unsatisfactory, which is she can't recover anything. But it also shows you how how the law can change.
Mm-hmm.
And in this case, possibly change through the diligent activities of some lawyers and Lord Moncrief, who just wouldn't give up.
Yeah, who said, you want to try again?
Yeah.
And again.
The other thing on this one is that the facts are memorable and gross.
Yeah, no one forgets. And this is, I mentioned, I think this is the members only. There's the law, the case we learn about in law school in the US is the Hairy Hand case. Because it's a dude. It's a skin graft that goes on his hand, and his hand it's a hairy hand. He has a hairy hand. And it's a question about compensation and what's the damage? How do you calculate damages? But it's the hairy hand case because you can't forget it. They give you these cases because you can't forget the stupid case.
And the other one about remoteness, where it's the explosives on the train station.
Yep.
You guys cover that one?
Yes. And several like it. The Chinese t-shirt factory, the t-shirt factory case.
Yeah. The one with the barrel that rolls out the window.
Oh yeah. On Respondeat Superior.
Yeah. All these things, like we learn these cases in part because in law school, they know that first year law school, you are not yet ready to
process.
You're not yet ready to dig into like boring cases. Because a lot of cases are super boring. It can literally be like one accountant made a math error, and then does this turn into something? So instead, they cover cases with interesting facts. Do you guys cover the Fox case?
Which Fox case?
The Wiley quadruped.
Wiley quadruped.
This one is another UK case, so you might not cover it. It is a prepossessory interest case. And so basically what happens is one guy is hunting a fox. And part of hunting a fox is that you keep chasing it until eventually it sort of runs out of ability to keep running, and then you capture the fox.
Okay.
So he's hunting this fox for like several days. And then somebody else comes upon the fox that's already tired out, and he happens to have a gun, and he shoots the fox and says, "This is my fox now." Meanwhile, the guy who spent all day trying to hunt this fox is like, "That's my freaking fox." And everybody involved is rich, and so they can afford to have this giant legal battle over
a freaking fox,
over this fox carcass, which is worth way less than the lawsuit, right? But the question is like, when do you get a property interest in this fox?
Yeah. It's when does it vest? When do you have it?
And then this case ends up being part of the legal background for the baseball case.
Wait. The guy that shoots it gets it, right?
I believe so. I'm now trying to remember. Yeah, it was like you're trying your best, but until you actually collect it. Pearson v. Post is the case.
Yeah. I think the guy that shoots it gets it.
Yeah, they say mere pursuit of the wild animal does not give you a prepossessory interest. It's just like, sorry, you were chasing it, but the guy who actually gets it, they say it's rude, it's mean to shoot the fox out from under this guy. But yeah.
It's poor form, but it doesn't change possession and lawful entitlement.
Well, I mean, the other thing is my dad and I were out camping at one point, and we're there, and this moose wanders out into our campsite, and this moose has been shot. Like, it has clearly been shot. But it was shot sort of in the rear area, not shot in the butt, but shot like through the intestines, right? It's not a good shot. And so this moose it's taken a while to, this moose wanders into this campsite, and it's clearly going to die, right? There's no way this moose survives this shot, but it has still got a lot of run in it. And so my dad happened to have a firearm with him because
here we go.
It was bear season. And so he shot this moose because the moose was dead already, right? It's just like, we got to make sure that this moose does not suffer. Anyway, about like 15 minutes later, this guy comes in tracking this moose. And he is pissed because he thinks Well, he thinks Dad is trying to claim this moose. And Dad's like, no, it's your moose, dude. Like,
Oh, your
you can
dad did
have
the
the moose.
classy thing, not the relying on the law thing.
My dad didn't have a hunting tag. He's not actually entitled to take possession of the moose.
Oh, okay.
He's just shooting the moose because the moose is gonna die, right? It's just you're doing a kindness to this moose. Because it's like it's dead. It's gonna infect, it's all of that, like everything in your intestines and so forth. Does not do well in your bloodstream. So it's gone. But this guy was super pissed. He's like, why'd you shoot my moose? And it's like, still your moose, dude. I just saved you another like hour of chasing it. And so finally this guy realizes that Dad's not trying to take his moose and is like,
Thank you.
Okay. So yeah, the guy takes his moose and that's the end of it. But
All right.
yeah, it's
Back to this one because we're not talking about moose.
no. So McPherson, the British Motor Buick Motor Company.
Last point: critical case for product liability.
Yeah. This one is so like this principle in this one is so important for everything you do. And I'm just going to say, look around you right now and try to evaluate how many of the products around you are ones that you bought directly from the maker.
Yep.
And I put this up in my parting thoughts. And I can say very few of them. I made my own wallet. I made my own belt. I own a few things that I bought directly from somebody who made it. My kukri I bought from the guy who made it. But like my computer, not even close. My desk, nope.
Well,
my
even
phone,
parts of it, like the pen, this pen that I'm using, I made the pen, but the pieces of the pen.
Yeah, the mechanism.
The mechanism. I didn't forge the steel. I didn't not every element of this did I create.
Yeah, it's you just don't know, right? It's so, you know, in most of the cases, if you ask me to go and find the manufacturer of something, like who specifically made it, I couldn't. You know, I'm drinking a glass of scotch. If you ask me to track down the person who has actually involved in the distilling on that particular day,
yeah,
good God, no. It's just not even remotely doable. So, and dangerous products are a public ill, right? We can think about how awesome it is that we go into like a supermarket and I can buy Coke, I can buy a steak, I can buy scotch, I can buy whatever, and I can rely on the fact that unless I like leave my steak on the you know, on the counter for a couple of days, it's probably going to be pretty safe to eat.
Steak's probably still fine. It's the chicken you got to worry about.
The chicken, yeah. The Coke is going to be fine like to like 2030.
Concept is still the same though.
Yeah. I can rely on all of these beverages being mouse free.
Yes.
I could buy ginger beer bottles for the rest of my life and never see a mouse.
And not be seriously concerned that there's a mouse in there.
Yeah. And I actually think that this case was in a lot of ways inevitable. And what I mean by that is that I think that it's so important that somebody would have come to this like principle either through the courts or through government having to say, listen, we're going to step in here and say this is going to be the rule.
And there's another principle here. Like this is one of those things where the law needs to provide stability. And there's a reason why the law moves slow. People get mad, but the law has to move slow. It has to move slow because you need to be able to rely on your understanding of the law when you're out there as a manufacturer producing something. You need to know what your exposure is.
Yep.
This was a lesson to every manufacturer. It was a statement to manufacturers saying, hey, liability is this is a way that you can become liable. So govern yourself accordingly. So that's a huge step in the law, but it has to move slowly. If you start changing these things all over the place, then you don't have manufacturers willing to manufacture. You don't have consumers willing to consume. You basically create stagnation. You don't want that. So you want the law to establish bedrock principles that everyone can rely on. And it takes longer to get there than we might like, but the fact that we get there is huge.
And I think that's an important thing to remember. People often want the law to move faster than it can, but there is tremendous value itself in the law having some stability. If Rob and I want to get into a business arrangement, right? Like, let's say we're starting a law firm together. We want to know that, what our deal means, right? If we put down that we have a contract as to like who gets what and so forth, we both want to know that we have a good grasp of what actually we're agreeing to. And if the law is changing all the time, then we don't have that. So, yeah. I think that the court would have gotten there, but it might have taken a while.
Yeah, would have.
Yeah.
Wait for the right case.
And
snail.
If not for that, this snail would come after you and everyone you love.
You don't know if the snail existed. That snail is a hypothetical snail. That snail is nothing to me.
Hypothetical snail.
That snail is nothing to me. You are a figment of my imagination, you snail. Because I don't know if you existed or not. You are cute.
And a complete side tangent. In law school, when there were students who annoyed the law students, particularly by being noisy in, there would be people who'd be noisy in the law library.
Oh.
And often they'd be referred to as snails for students not actually in law. It's like, why are you in the law library?
These are these dumb acronyms we come up with in law school that we think are so cool and witty at the time. And you get older and you're like, this is the dumbest thing I ever thought of in my life.
Well, I mean, in hindsight, I'm just like, I don't care who was using our law library.
Kurt's going to supply moose steaks and moose accessories. Kurt, keep an eye on your P.O. box. I sent something to you yesterday.
Hopefully it's not a moose steak, because
it's not a moose steak or a snail. It's neither of those things.
Because by the time it arrives, it might be not ideal.
Yeah.
I got moose tags, so I'm going to try to get a moose.
I have F-bombs.
I like the F-bomb.
These are great because I just throw F-bombs. They're fun to toss over your shoulder.
Please tell me you brought one to court.
No. I haven't been that brazen yet. Could you imagine? I don't want to imagine. I'm not going to do that. I'm not going to do that. That would be terrible. Your Honor, I have so many things to say, but this is just going to throw it over my shoulder. Nope. Not gonna happen.
Know what just occurred to me? One day, Judge A is going to retire.
Yes.
And she's going to have a retirement party.
Oh, that is fair game.
And that's the point where it becomes appropriate to give a judge a gift.
So judges, when they retire, a lot of them become mediators. So the chief judge in Fairfax before Judge A, actually before Judge White, was Judge Roush. And she became a mediator. And I had her mediate one of my cases, and she came in. Mediators come into your office, and they're there, and they're dressed like normal. They're not wearing robes or anything. They're mediating the case. And we finish. We get an agreement, and Judge Roush looks up at me, and she goes, "I hug now," and she reaches out and hugs me, and I was like, "Oh, I'm so uncomfortable." I didn't know what to do. I returned the hug, but it was like it was a weird thing for me. But it's fun seeing them out of the robes and just like
So
judges,
weird
like people.
judge out of robes circumstance.
Yeah.
So I'm wandering around the mall, and I see this person who gives me this look and I'm like, this person looks really familiar, but I'm not placing it. And they clearly recognize me. And I'm just like, so I just kind of go and I'm like, they recognize me. I'm not recognizing them. I'm going to lean into it. I'm just like, hi, I know you from somewhere, and I'm not placing it. And they're like, Mr. Runkle, we have a 3-day trial scheduled next week. And I went, oh shit.
Oh,
this is a judge.
Oh no, this is the worst. This is the worst thing ever.
Because it was a judge out of robes, and I just like, and I was like, oh, sorry, sir. And he's just like, no, it's fine. I did the same thing when I was in your shoes. And I was like, oh, I hope. And he's like, you haven't done anything inappropriate, so don't worry. Like, you're fine. But I'll see you next week. And I was like,
it's so funny. And now that I have a friend who's on the bench in Florida, and I got to go observe her. She was judging. I was just observing the courtroom, but I'm hanging out with her in chambers because we're law school friends, and I'm hanging out in chambers. So the bailiff comes out and escorts me out from behind chambers, and I go and sit in the gallery. So I walk out from behind chambers, escorted by the bailiff, and I go and sit in the gallery behind all of these young prosecutors and defense attorneys. They're all young. They're all either PDs or state attorneys. And the judge comes out, and here I am just sitting there taking notes. I'm honestly, I am drawing plans for a shelf that I had to make. I am drawing plans for a shelf. But every one of these young prosecutors and defense attorneys keeps looking over their shoulder because they look at me and it looks like I'm taking notes. I just came out from judges' chambers, and they think like I'm a spy or I am someone that is significant. And I'm just sitting here doodling. I'm drawing the plans for a shelf that I have to make in the shop and just listening and watching my friend be a judge. And I had the most fun doing it. And finally, after the full docket, so that the judge lets it go the full docket. My friend lets it go the full docket. And this is when Judge Ashley, Judge A, we can call it Judge Ashley. She finally has all the prosecutors stand up and says, "Counsel, if you can all please rise. I do want to introduce you to a friend of the court," and has me stand and I just wave at him and says, "He's just a law school friend. You might have thought he was observing you. He has not been, although he does give me information about what's said in the gallery." Just scaring the living crap out of these kids. It was, and I mean kids in the nicest sense, like young attorneys.
And the thing is as I'm now an older lawyer, I love, and people hate this term, I love the baby lawyers. Because, they're all like super keen. They're still figuring everything out, but it's just like, they really care about everything. Some of them will continue to care about everything as they go, but a bunch of them are going to become jaded, cynical, husks. And I'm like, no, keep caring about things. This is the best, this is the best thing. And they're always so nervous.
Yep.
And I can tell you, there's a lawyer who still just thinks, super highly of me. Like, he just really likes me, because at one point he came out, like he argued this sentencing, and I said, "Hey, you just had a sentencing. Do you want to talk about it?" He's like, "Can we?" I'm like,
Yeah. You're like, absolutely. I would love to.
Like, you did really good on this. I would have also cited this case, but you did really good. Like, don't take any. I'm giving you pointers for improvement, but I'm not here to bash you. Like, you need to understand. I'm like, you were scared shitless up there. And he's like,
mm-hmm.
I'm like, you were though. And he's like, yes. And I'm like, you don't need to be, because I can tell you did better than a lot of lawyers I see. And I know it takes a while before you can fake the confidence, but get up there and rock it, because you were doing great up there. You did good work for your client. You did great. And he's like, oh man, like nobody tells you any of this. I'm like, I know, I was in your shoes, and you walk around going, I'm doing all this legal work and I have no idea if any of it is any good. And, but yeah, he is, every time I encounter him, he's always like super happy to see me. And it's just because it was like a friendly face during a crappy time. So, it's just like, yeah,
there are judges, and I've had a couple of them do it. I remember the first one more than anything else, where after the case is concluded, we've shaken hands, and the judge says, before I depart, counsel, I'd like to see you at the bench real quick.
yeah.
And you're scared out of your mind, because when the judge says that, you're running through your head going, oh my God, what I do. And you're walking up there sweating bullets, and the judge, I remember it like it was yesterday, even though it was 12 years ago. And the judge leans over and says, this has been the third or fourth time I've seen you in front of my court, Mr. Morton, and you as well, counsel, to the other attorney. I just want to say that if this is the direction the bar is going, I'm very proud and happy to see and have you. You are welcome in my court anytime. You exemplify the profession. It was one of those moments where I will never forget that. I will never forget the impact that had on me as an attorney. And it wasn't just, he wasn't the only judge to do it. Others have done it. And I think that for all the judges out there, the amount that you can do to a young attorney to sway them in the right direction just by doing something like that is immense.
I had a judge who gave me no end of grief, like no end of grief. I'd go in and she'd ask me like trivia questions. She would just like, if I didn't do something perfect, she'd be on me, like, just like, oh, well, you need to, like, why didn't you do this? And I'm like, and so after a bit, I was there doing duty counsel work, and she said, everybody leaves, and she's like, Mr. Runkle, if you could stay behind. Madam Clerk, you're free to go. I just want to talk to Mr. Runkle. And I'm thinking, oh, crap, I'm about to get yelled at. And, so everybody else leaves, and I'm sitting there like, she's like, I just want you to know that I've been a little harsh on you. And, she explained why. I'm not going to specify the reasons because it's kind of throwing another lawyer under the bus. But she said, it's clear from your, conduct in my courtroom that you are diligent and you are, and she's like, I'm going to be less hard on you going forward because it's clearly not necessary. That said, that is not an excuse to start slacking off in my courtroom. And I was like, understood. But yeah.
I've also had a judge where I had a fever. I tried a case with a fever.
Ooh, I've done that. It's not good.
And the judge actually called me up after the case was done and asked and said, Mr. Morton, are you okay? And I said, Judge, I'm all right. He said, because I've had you in front of me several times, and you just appeared a little off, and I just wanted to make sure that you were okay. And honestly, that is almost just as impactful as the judge that gives you the high marks. Like when the judge knows who you are and what you can do and what you're capable of, and then is asking if you're okay, honestly, it's pretty cool.
I had a trial that I ran with the flu, and the Crown prosecutor would have given me the adjournment if I asked for it. Like if I'd said, hey, because I was stupidly sick.
But that's
I actually had
detention for your client, and that's all the other stuff.
I actually had to get helped out of the courthouse by a friend of mine because like I walked out of the courtroom when the trial was done. I sat down and I was like, I'm having a hard time getting up. Like I am really doing bad. And so they helped me out, and into an Uber, and the Uber driver actually helped me into to my door, which was fantastic. But the only reason why I was running it that day, why I didn't want to get an adjournment, is that the Crown was missing a key document that they needed to prove their case. And if I give them the time, they can fix that problem. Somebody will notice it, somebody will fix it, and my client ends up going to jail where they wouldn't otherwise. And so I'm like, and I told my client, I'm like, literally, this is a trial where all I am doing is just sitting there waiting to object when they try to tender this thing that they can't get into evidence.
Yep.
I'm like, I will be doing no cross-examination. I will be doing nothing other than just sitting here waiting for them to like have their key moment and then blowing up their case. Like, that's how this trial goes. And he's like, I understand. The thing is your client tells you that they understand this. They don't actually understand it when they see it in practice.
Yeah, it's nerve-wracking. They hate it. They can't stand it. They don't understand why you're not doing anything.
Well, I'm sitting there and I'm like this, like through this trial, just like I need to keep enough of my brain going to spot when this moment is, and everything else is irrelevant. Like, everything else doesn't matter. And I'm just like, and so the judge goes, Mr. Runkle, are you okay? I say, I'm all right, sir. And he's like, because you haven't asked a single question on cross-examination. I say, I know, sir, that's the plan. And he's like, and the judge is concerned because he's like, this is a stupid strategy. And like, let's see where you're going. But the judge also, like, I actually talked to the judge later. He's like, anyone else, I would have been like, I am not continuing to run this trial. We're going to go and have an issue there. And the judge was like, I've seen you before. So I was like, he's like, I thought I was going to trust you. So then the Crown goes to tender this key document. And I'm like, that document is inadmissible. It's defective. I object.
This is a great question.
The reason why I knew it was coming, it's a possession of stolen property case. And so they have like the police officers to say that they find my client possessing the property, etc. The issue is a document called a statutory declaration. And the statutory declaration is a shortcut in evidence. It allows them, instead of calling the property owner, in this case, to tender a document to say, from the property owner to say, this is my property. I didn't let this person use it. I didn't, it was actually stolen goods. Yep. And the problem is it was a defective document. They had messed up this document. It was not admissible. And if you want to rely on an evidentiary shortcut, like a statutory declaration, you have to meet the statutory requirements for it. And they hadn't. Mm-hmm. And so it was literally just, I'm waiting for them to tender this document because I know they need it. And I'm like, you can't tender this document. It is defective. And so they come up with a document and I'm like, I object. It doesn't do this. It doesn't do that. And the judge is like, yeah, he's right. Documents inadmissible. Crown, do you want to call a witness to cover this?
They don't have a witness on call. They don't have one under subpoena. They're screwed.
They don't have a witness on call because the property owner has not been subpoenaed. He's not at the courthouse.
Yep.
And so the Crown just, like, the prosecutor just goes, we don't have a case anymore because the guy's charged with possession of stolen property and they can't prove that the property is stolen. Okay.
Yep. And I mean, people are sitting there saying the thief got away. You know what? Cassie, it's not that.
I'm the defense lawyer. That. I'm the guy who did my job.
It's Ian's job.
If you want to be upset with somebody, be upset with the prosecutor who didn't do their job.
Correct. And it's one of those things where people talk about this. It's not like it's a game for us, but people ask, how did you know that document was coming in? Because litigation is 4D chess. You are planning your own case. You're trying to plan their case. You're trying to think what they need in their case and how do I beat it? But then you're trying to
Yeah.
also think, how do I prevent them from pleading their case? And then when the case is going on, there's other things that come up during trial that you didn't foresee, that you might have needed to, that you're trying to navigate. It's 40 chess at the highest level.
You have
And
to,
yeah,
a good lawyer is always somebody who can look at the other, like step into the shoes of the other side and go, if I'm my opponent, how do I win this? And where are the critical points? A legal case can sort of be visualized as like a web of evidence. And you've got certain points that web has to reach. And so you're looking at how many strands can get you to that point. And if there's a place where you're like, that's a vulnerable place where I can break that chain, as a defense lawyer, my ethical responsibility is to do that. My job is not to convict my client. My job is to ensure that A, the government follows the law, B, that that they actually can prove the case beyond a reasonable doubt, and that my client has received the best evidence. And if the judge was like, "I'll allow that document," I would have won it on appeal.
You have to be, but you have to be ready for that anyways. You have to be ready for every plan that you have to fail.
And the thing is it was literally, if that document goes in, we're out of arguments.
Convicted. Yeah,
like that's it. But at the end of the day, it's just like, my client understood initially what the case was. I had written instructions that detailed how I was going to run the case, which was basically, it's all on this document. That's where everything lands. And the thing is what is it? Somebody says, how did I know the document was defective? They're required to disclose the document to me before the case. And so I see the case, like I see it and I'm like, that's not right.
Yeah, because you can require them to put the witness on. If they give that affidavit, you can object and you can say, I don't buy this, put the witness on. At least in the US, I can get over the hearsay. If they say they want to rely on this affidavit, I can object to that and say you have to put the witness on.
In Canada, the way it works is that the stat deck, if it's admissible, I can't tell the Crown how to call their case, but I can object to the document. And so if the Crown has chosen not to bring that witness, then that's on them. But I've had another case where I was like, I got the document knocked out. And the Crown's like, cool. Your Honor, can I have an hour? Like, can we, we booked this for the whole day. I just want to take an hour's recess. And the judge is like, I'm going to allow this. And I'm like, fuck. Because they called the person and they brought them in. And that was it, right? Like, that's it. It's just straight up. But yeah, I mean, I was so sick and I still won the trial because that document went in. But like, it was literally, I couldn't get the adjourn. Like, I couldn't in good conscience adjourn it because
you had to run it.
Yeah, exactly. Because if it goes over, like they set another trial date in 6 months, another prosecutor looks at this document and goes, that's not right, fixes it, and now my client's getting convicted.
And that's something that happens. Like, you run on adrenaline, and I've told this before, the amount of weight that attorneys will lose during trials, the amount of just, they will lose weight. They will not eat. They will become sick. Like, at the end of that trial, I've known attorneys that have gone feverish, had flu for several days. Every bit of energy you have is gone.
If I've got like a week-long trial, I won't book another week-long trial the next week because I'm like,
you have to.
I'm going to be garbage. But we should read some super chats here. My throat is starting to give out because I've still got the still battling. And some people have asked out of concern. They're like, hey, do you have COVID? I do not have COVID. I've had multiple tests, but I also have I've got asthma, And I had surgery on my jaw that sort of messes with my swallowing a bit. So sometimes I get, sometimes it moves into my lungs, and that's just the circumstance there.
Yeah, and I went and caught a cold this past week.
Oh, that's no good.
No, especially because I've got so much work to do before September 5th.
Oh, you got a big trial?
No, that's the transition to the new position.
Oh, the new position. Are you allowed to say where you're ending up, or just?
I'm not going to say where I'm ending up. It's a firm that's in existence. Several attorneys. I'll be joining as a partner, and it comes September 5th.
Nice. I mean, the details I know, it's a position where you've got access to a lot more resources. You're going to be able to run bigger trials, better, like all sorts of things. You're going to have junior lawyers under you.
I need to go. I get to try cases rather than do a lot of the other stuff.
So, when you think of like Elaine Bredehoft as the, and I mean, that's not a statement of competence because Rob is way better than she is.
But it's the resources behind them.
The reason, like, where you get to be the lawyer who has other lawyers behind you doing doing research, doing legwork, where you're like, I need a brief on this legal topic by the end of the week, please.
And I can go into court and focus on the things I need to focus on and not worry about all the other stuff.
Yeah. And that is like a force multiplier that, you just sort of can't envision. So, yeah. All right. So let's look at memberships first. Emma Z, thank you very much for 5 gifted memberships. Celine, apparently some people have been having trouble with super chats. If you have, such is life. I mean, I appreciate super chats, but at the end of the day, we'll live. But apparently you were trying to say, Nicole and I just want to say we appreciate you both. Thank you for everything you do. For some reason, YouTube isn't letting her send a super chat, so I'm sending it on behalf of both of us. Jan, thank you for 5 gifted memberships. All the Happy Squirrels, love that username. Thank you for 5 gifted memberships. And Equality, thank you for 5 gifted memberships. Also, please like the stream. It's always helpful. Mm-hmm. Carolyn Mercer, thank you for the YouTube membership there. Crazy Cat Queen says purity of content, first world problems. I mean, in some ways it is, right? Because, but I mean, it's the sort of thing that we think should be a problem. If you want to manufacture foodstuffs, they should be safe for the public.
Yeah, foodstuffs get consumed.
Yeah. Do not ask about ketchup and the presence of rat byproduct.
Ew.
Christian M96, if I could trap mice in a bottle, the first thing I'd like to do. Christina B says, my favorite duo. Much love and thanks always. Thank you very much. Carmen L, thank you very much for the YouTube membership. Nicholas Staro's Trial Watch, check out his channel. 30 minutes behind. Rob could sue over the tie, attempt a forceful contract, primitive contract for Ian's use of tie to make Rob create content and humor with tie in the background, theoretically against Rob's will. I mean, right, Rob could have done whatever he wanted with the tie. If he wanted to just yeet that into the trash bin, that was entirely
why would I do that? Why would I do that?
I mean, if not Sue Kendall, I was wondering if Ian has been impacted by the fires. I am well away from the fires. They're mostly in British Columbia. I'm in Alberta. Some of my family members are near them. My dad was saying that he's out in Kelowna, and he was saying that he could look across the lake and see like a wall of fire out on the other side. But apparently Kelowna didn't lose a single house. So, yeah. I'm fine. All of my family is fine. Everybody's fine. So thank you for asking, but we're good, which is great. Nicholas Starro saying, fun fact, this case also led to several laws implemented that says that health and security on the workplace cannot be delegated down from the owner.
And Nicholas is the employment attorney, so he would know.
Yep. I'm going to sending love from Jackson, Ohio to all of you tonight, especially you and Ian Rob. Apparently some people are having trouble with super chats where the super chats aren't going through, but they're getting billed. I don't know what YouTube is doing, so I'm sorry if that's the case. It's just YouTube does its things sometimes. How have we gotten through this without a single Strange Brew reference, and why would we want to? Now, I don't know. No to Disney. Mickey on bottle, good. In the bottle, bad. There are places Boppet says there are places you should not put hot sauce.
Lots of places. Lots.
I'm just going to say, if you want to start getting into really spicy hot pepper stuff, learn to wash your hands very well. It's an important life skill.
Yes.
Yeah. Before you, if you've been handling peppers, before you touch your eyes or genitals, make sure you wash your hands thoroughly and test them by touching somebody else's eyes or genitals first. Not legal advice. 9 Inch Nails Gal saying 9 months as a member now, and I'm imagining a special on fire and needing ice sticks. Thanks, Ian. Thank you very much. Thank you so much for being a supporter there. Grant Horn, I doubt I can consider you a serious jurist. I hope not. Christ, serious is boring. I hope I'm a jurist with a sense of humor. So, Kelly GB, in Brazil, every lawyer needs to promise to fight for the law. If the law is in conflict with justice, fight for justice. I like that. Dayslav Act Mandate Carry, keep fighting. Thank you very much. Can confirm this is in New Zealand law. When I did my law course, it was one of the cases mentioned.
There you go.
Snail emoji. Celine says, I sent a super chat, but YouTube ate it. Hope you still get paid. I don't know. YouTube is...
that's weird. That is weird. You're not the only one. At least 3 people have said that tonight.
Yeah.
We don't have any control of that on StreamYard side or YouTube side.
YouTube sometimes does weird YouTube things, and it just is what it is. So if it doesn't go through, I appreciate the sentiment. So Kristen M96, testing super chats acting sus. Test succeeded. Jan says, love that Scott's Law has these cases. Thanks, Ian. Thank you very much. I'm pretty sure this is the Jan I know from Scotland, so who has been a tremendous friend to me. So thank you. Aqua says, terrific trials of the century tonight. Ian and Rob, thanks so much. Although I don't know that I've been the best friend to Jan because I led her to the world's worst French restaurant in Edinburgh. Leon by the Sea, thanks for helping make time bearable. In ER with the 93-year-old dad, 8 hours. I'm hoping your ER experiences are better than mine have been, because mine were crazy.
Yeah, I'm sorry about that.
Sandy says, thanks, gentlemen, for another wonderful episode. And an emoji that did not come through. But thank you, Sandy. Ian, Rob, and Chat, thanks for a great Trials of the Century. Thank you so much. We love doing these things. One of the things we really love doing these things is just that we get to pick trials that are neat to us and dig into them. I learned a bunch of stuff about this trial. The whole thing of the judge being the same judge as the next time and the lawyers being the same lawyers the next time. I'm like, what the heck? So all of that I didn't know. That wasn't covered in law school, but it's fantastic. Ryan YYC, the only technicality the criminal gets off is by a technical error by the prosecutor. Fair ball. every time somebody says that somebody got off on a technicality, it falls into one of a few categories. One, the prosecutor screwed up. Two, the cops screwed up. Or three, they violated someone's rights. Those are what the, and all of those things are reasons why they should lose. Equality says, I thought the super chat problem was just me. Apparently, it's a YouTube problem. It is what it is. Cat W, I hope you feel better soon, Ian, and congrats to Rob. I am really glad. I don't know. Can I say that you were nervous about? I guess I just did.
It was a lot of pondering. It was a lot of thought. It was not taken lightly, but it's the right call.
It's always tough when you're making a big change, but it's I think you're making the right call, and I think you think you're making the right call, so we're all in a good place there.
Yeah.
Super chat probably because YouTube can't figure out US dollars to Canadian dollars. So fun fact, if you donate in Canadian dollars, YouTube converts it to American dollars before they give it to me. And then I get it in American dollars, and I have to, when I'm doing my taxes, convert that American dollars into Canadian dollars for whatever month I got that money in.
I remember you talking about that last year.
Oh, it's taxes have become a major pain in the ass, is what it is. Congrats, Rob. Thanks for the great trials of the century. Oh, thank you. Thank you. It's almost time to escargot to the next trials of the century. Nice. I'm in the Kootenay area, not too smoky now. That's good. And I see Jen saying happy Trials of the Century is back. Congrats on the new job, Rob. I think we are super thrilled to have Trials of the Century back. It was Rob started this project ages ago. I'm glad to be along for the ride. It's such a fun project, like looking into the legal, the legal issues and so forth. So, yeah. Amber says, feel better, guys. Awesome. Equality says, I thought I was saying bad words. Replay crew. And we've got Lady Draconis with an important question. Do you have the next Trials of the Century case, Rob?
So I want another crack at one of two of them, and I'm trying to narrow it down. Maybe the chat can help me. Lindbergh or what was it? Not wait, hang on. It was Lindbergh. What was the other one I wanted to do? Darrow's closing. What was Darrow's closing? Clarence Darrow.
I mean, Darrow was amazing at everything he did.
Leopold and Loeb.
Oh, yes.
So the question is Lindbergh or Leopold and Loeb? That's my question between those two. So
let me just make a poll.
Because I have a very keen interest in the evidence presented at the Lindbergh case and the bias that existed behind that trial, how serious it was. And then Leopold and Loeb, because Clarence Darrow took a case that was a losing case. It was a lost case. He was arguing against the death penalty.
Oh, it was absolutely like a loser case. And yeah.
But he just lobbied the court for, I think it was, his closing was what, 9 hours? So
I think so. And I misspelled Lindbergh, I think, but oh well.
But it's Lindbergh. It's a Lindbergh kidnapping or Leopold and Loeb. I want another crack at those.
Ooh, this is a good suggestion.
Oh, hey, Danny. Ethel and
hey,
Julius
Danny.
Rosen.
We have not been on a stream in a while, so
didn't we do Ethel and Julius? Wait, I think I have.
We got to redo it.
We got to redo it, but we did do it originally, so we have we had the notes. I just got to redo it.
Yeah.
Good case though. Great case.
Great case. Danny, we got to end up on a stream again together. I'll send you an invite on Monday. We gotta fix that because it's been a while.
Yeah.
And
I've just been I've just been off of everything with this transition to the new job.
And we've got thanks for taking the sharp edges off my workday. I'm glad. Equality says $2 goes through, $5 doesn't. Weird. I don't know what's going on. And Hannah B says, after the Ian Get Ready With Me video, Rob, the gauntlet is thrown down. I understand you're working on one.
Yes, I've got a whole plan for it. I just need to get time in the shop. Yay, yes.
I got to say, that Get Ready With Me video was a lot of fun. Actually, hold on 1 second. I'm just going to be right back.
Yeah. Well, and to those of you in the chat that are asking if I'm still going to be in Virginia. Yes, I'm still practicing family law. Yes, I'm still going to be on YouTube. These were all kind of conditions that were kind of negotiated. Yes, it is exhausting. I have owned my law practice for 12 years. That law practice is closing. So I have to basically make sure all of my files are up to date. All of the conflicts checks are up to date. All the vendors are up to date. I haven't been sleeping much because of all of that. It's a lot of work. It's a lot of stress, but it's one of those things that feels like it's so very worth doing. Yeah.
I had to make this for that video.
The hot sauce. I know the hot sauce on the front of the shotgun. God,
this is a thing for an underbarrel hot sauce thing. And the thing is I cut out these little hexagonal windows because you couldn't see the hot sauce well enough. So I was worried that you couldn't tell what it was. It's got baseball stitching.
Yep.
It's like this thing actually is like an actual little like project. And I was just like, yep. I don't know. Some people have asked me to take it to the range and try shooting it. I don't know because I'm worried about how the glass will deal with like the shockwave. So I'm concerned about that. So if I do that, I'm probably going to do it wearing like, the full like angle grinder mask.
Yeah, I would, just in case that you never know what that's going to do. That's going to, because the percussion off the barrel could shatter the glass.
Yeah. And if it turns into like flying shards of capsaicin soaked hot,
nope,
glass.
Nope. Mask. Just face shield.
It's like safety glasses are good. Face shield is better because I still wouldn't want to catch like a piece of capsaicin soaked glass right across the, across my cheek or something. So yeah. I might do this, auction it for Stollery donations. I'm going to auction a few things that have been in some of my videos. I will probably auction the, this thing, which is the emergency like police advice kit. It goes like this.
Oh God, Ian.
I'm also I mentioned
someone was asking about the gavel.
People have asked to buy this rock. I'm gonna auction the rock.
Why?
It's in one of my videos where I comment that a rock would be a better weapon than this other object. So I'm going to sell the rock.
This is the coolest gavel in the world.
It really is.
So this was given to me. It was a gift. And I don't have the note in front of me, and I really wish I did. But this was created, I think, by Wisconsin Department of Forestry products for the Secretary of Agriculture. And there are 49 different species of wood that make the gavel up, and they're all numbered. And each of those species is from 49 states that were in existence at the time the gavel was made. So this sits right next to me, and I'm very gentle with it because the provenance is I'm very gentle with this. I need to copy this before I handle it too much that it breaks.
That is so cool.
It's one of the coolest, one of my most treasured things that you guys have given, and it is really neat.
Chat, I am really bad at sending thank you notes, but people send me things and I always treasure them. I am just really awful at sending thank you notes.
I have a list, and it's right there. And I've got stuff going out this week. I've finally gotten to get some of the stuff in packages, so I am sending stuff out this week.
I gotta get a better system because people send me stuff and I'm bad at properly sending back a thank you. So I got to do that. So, and we got some more super chats that came in. Kristen M96 says Rob looks like he needs a hug.
Virtual hugs are great.
Celebrial82 says thanks for the great trials of the century, guys. Feel better. I'm working on it. I'm back up to like 85, 90% somewhere in there. It's just slow. I cough up stuff and it's like, okay, how much stuff is there in there to cough up, I guess. So yeah. Equality, thank you very much for the super sticker. Much appreciated. Baby Gator says, I hope this allows for more free time / family time and rest for you, Rob.
Me too.
Rest is not something that happens to lawyers.
No, but the resources to not have me stressing every waking minute of every day before trial would be helpful.
That would be a big thing. So, Ancient Maverick, you guys rock. Thanks for the excellent content. Thank you very much. All the Happy Squirrels says, can you explain the hot sauce bottle holster thing? So I did a video that is a get ready with me video, and people asked me to do a get ready with me video, and I said, I can do that. I just am also incapable of taking it seriously. And people said, excellent. That is what we want to see. So I use this thing as part of that. It is under the shotgun. Hot sauce plays a major role in that video. And all I can say is check out the video because it is weird in ways that I'm not sure I can explain.
Well worth watching. It's a good 10 minutes of just, it'll make you smile. It's a good one to watch before bed.
It's just my sense of humor gone wild.
Yep.
So, Judy, you got this? Sometime I have to tell Rob about my connection to the gavel from Wisconsin.
Oh, anytime, Judy. Anytime.
And the lady in black says, I'm a former CRA and would happily help RE taxes. Let's talk, because that's something I might need. New Zealand Butterfly Girl says, Rob, you need to make a holder for the gavel with some wood from Hawaii, and that will complete the 50 states theme.
I agree. I think that's definitely in the plan. I just have to find some wood from Hawaii. And no, you cannot ship me. You cannot ship me wood from Hawaii. Wood from Hawaii actually has to clear customs.
Oh, really?
So yeah, there's something about the travel from the islands. If you bring agricultural products from Hawaii to the States to domestic, I believe last my checking was that it still had to clear. Like you can't bring certain items.
All right. I'm just going to flag that as well. A chair guy told me Runkle is breathing wrong. That's a classic running joke there. Ian, good job articulating Commonwealth case law to the USA. I thank you very much. Boppet says nose boop. That's a puppy hug. Aw. Kalish says, can we embiggen the hot sauce holder? Super cool. I'll try to post like some pictures on Twitter, but that is the hot sauce holder. This is not my finest work. It is like I needed this done on a schedule. Like I needed it done at a particular time. So it's kind of like I got to get this ready, and there's various places where I could have like done more with the edges and so forth, but it is what it is. It's like we got to get that going there. And somebody says, "What is Get Ready With Me?" Get Ready With Me is a genre of videos where people prepare, like show their morning. So they show their like skincare routine, they show their makeup routine, they show all of that. And people asked me to do all of that, and I went, all right, that the basic concept is silly, but we can have fun with this.
Yep.
And I
if you have to ask, you have somehow avoided all of those very kind of cringeworthy videos.
and Leopold.
This one is not cringeworthy. This one's funny.
Leopold Nove is in at 56%. I can just say, like, my actual Get Ready With Me like routine would be I roll out of bed, I stagger up the stairs, I get a can of Coke, I walk over to my computer, check my email to make sure that there's nothing that is immediately on fire, because sometimes there is. And then either if I'm going to like a courthouse, get ready and like put on pants, in a suit and so forth, and just, drive to the courthouse. Or if I'm doing work on the computer, it's just like, do work on the computer. The pants are optional for that, unless you're going to be appearing on video links. Yeah. I have a fleece onesie that I sometimes wear when I have to just do computer work. Maybe I should wear that sometime for a stream.
Oh God, it's about to be winter, so it's appropriate.
Oh, it is so comfortable and it is so wonderfully lazy. But yeah, people are like, "What is your skincare routine?" I'm like, "Have skin." That is the routine.
Wash, repeat. Like, just have skin, wash, repeat.
Yeah. What hair care products do you use? I don't know. The ones my wife buys that are in the in the bathroom. Like, I don't like, what do you use to moisturize? I'm like, I don't though. What do you call it? I guess I do shave with like a like I use a brush and wipe soap on, and then shave with a like a safety razor, which I guess is a little unusual. I also bought a straight razor.
Yeah, that's unusual.
Although the straight razor is a little daring, I will say. I managed to cut myself plenty shaving with like the safety razor. So yeah. The straight razor is maybe a risk. My Get Ready With Me: wake up, grab coffee, brush teeth and hair, log in. I work from home. Yeah, it's pretty much that. Minus the coffee plus Coke. I don't even know that I necessarily like if I'm not going to be on video, it's like brush the hair. Nah. So, all right. Let us wind this up here, because I think everybody needs to get to bed, especially myself. Some people were asking, when is the long charity stream? It looks like that's November 4th.
Okay.
So I'm going to be doing a full day of full 24-hour live stream to try to raise money for charity. I'm going to have some stuff to auction. I'm going to have I got to figure out how I'm doing that, but yeah. All right, let's roll the sort of outro that I use here, and we will see everyone next time.